Sorry, we had agreed to start at 8:30. So I was just maybe waiting for enough quorum because I was just saying Patricia. But now Anne on board, I'm sure John must be on his way joining us. So probably we could start so that we don't delay the ending of this session as we agreed.
Yes.
What do you think? Anne, Patricia, do you agree with me?
I agree with you, Rhoda. We can they can join us as when they come and they log in.
So Anne, maybe you could start us off with a word of prayer, then we can proceed. Anne.
Okay. Let us pray. Father, we bless your name today. We give you glory and honor. We thank you for the gift of life that you have bestowed upon us even this morning, for the peaceful night that you gave us even as we rested, Almighty God. And we give up ourselves unto you. As we start off our training and meeting today, Almighty God, we invite your presence amongst us. You dedicate especially Rhoda, who is guiding us through. May you grant her wisdom. May you favor her, Almighty God. May we just get knowledge in you, Almighty God, together as we learn as a team, Almighty God. May this day be blessed only in your name. For it is in Jesus' name I do pray. Amen.
Amen. So thank you very much, Anne. And I think it's such a bright day today. It is sunny in Nairobi, and it feels nice to have another bright day. And knowing is the last day we have the last leg of this summit on industrial relations, I think we've learned a lot. So today we'll just be looking at the remaining topics, which are not so many. And I'm happy because the cases that we'll look for mostly we have mentioned. If it's about the CBA negotiations, we've been talking about how the unions work, how they work with the union, and the things to look for probably in the CBA. When it comes to the international or the ILO, already when we were looking at international law in the labor laws yesterday, we looked at some of the conventions we have, and probably it will just be an overview. Then the case studies that we have selected, we have two case laws that we're going to look at. What I love about these two cases, one of it is very recent, and it is one of the, which is a Supreme Court judgment. It's one of the latest judgments that we have on WIBA. You remember us saying the WIBA is one of the acts that has been really challenged in court about the constitutionality, and we didn't go ahead to say which clauses have been contested and why, and probably what is the pronunciation of the courts, especially the highest court in the land. If you look at the statute, it's affecting a lot of people, and the petitioner is the Law Society of Kenya, and the first respondent was the Attorney General representing the government, and court was also admitted later. And we will see the arguments. And what I'll do with the case studies, because like the judgment, it's quite long. The Court of Appeal and Supreme Court's judgments are normally very long. For those who maybe managed to look at even the BBI judgment, which is a whole document. So this is a 16-page document, and we may not go word to words, but for us, it's just to walk us through and to stimulate our thinking and how we look at the case laws, and probably to see going forward, do we look at judgments or any rulings or any pronunciation of the court and the intimidators? So we should be able to look at the structure, how the courts brings about the ruling and the way they give the orders and the judgment, so that in future, and maybe the other cases, you can be able to Google, get those cases because they are public documents. You don't need to be given those. I'll show you how to just go and search. You download, put it in a folder, and then as you go through the cases, it's like interacting with the court, and you'll be able to see what the court looks at, what various advocates who are presenting maybe the petitioner or the respondent or the complainant and the claimant, what they go through and their thinking in terms of the analysis. One thing that is very good when you're looking at the case laws, it is different from reading the Employment Act or the WIBA. If I was to tell you read the WIBA from cover to cover, maybe the level of understanding before you get to clause 58, you have forgotten what you started with. But when you look at case law, which I find it to be the most critical or the best way to learn the labor laws, it will keep on referring to so many clauses and any other law that is related to that impasse. So you are able to understand it in a very broad perspective, rather than just reading a clause by a clause the way we do like the Employment Act. What does this clause say? So we only cram and know that provision, but we should be able to understand the general and the context behind it and the historical development of such laws, where they came from, whether it's from ILO, what was the intention, what was behind it, what was the motive, what was the thinking, what was it trying to cure. So if you understand law from that perspective, it becomes very easy for you, and it will be just the way you pick a book, maybe a motivational book, and you read, and you'll be able to understand. So you can even give yourself a target, like every month, every week, I'll be looking at one case law, just one case law on a particular topic, and then we'll move. So it will be a stimulating discussion, and not per se reading paragraph by paragraph, and also understanding the structure of a case law. So that's what we'll cover for today. And I'm hoping by 11, you should have covered everything.
Rhoda?
Yes.
Bring in John. I think there's one attendee.
Oh, there's one attendee. Let me bring him on board. Good. John, kindly accept my invitation. So those are the scope of our discussion today. And apart from maybe the case law, the rest will be just a walkover of what we've been covering. So 3 topics. We'll start with Fair Administrative Action Act, which we have not looked, we may just have mentioned. Then we'll look at the collective bargaining, and then the ILO convention, and also the 2 case laws for employment and labor relations court. You will actually see the cases originated right from the High Court. It went to the Court of Appeal. Then if people are not satisfied, it's moved to the highest court in the land, which is the Supreme Court. And we agreed the matters that can go to Supreme Court are only matters that are seeking interpretation of the Constitution, and probably they are affecting the public. So you'll see, like the WIBA, it is affecting the entire workforce, all the employers, and probably the government, who are the 3. So it is a public interest case which has constitutional interpretation. So with that, allow me to upload my presentation on the fair administration. But maybe just to start us off, what is your understanding of the term fair administration action or fair administrative action? Yesterday, we looked at the fair remuneration and working condition. For what do you consider to be fair administrative action in your own understanding?
I think it's just justly managing employees. If there's an issue of disciplinary, are they listened to? Do they get a fair hearing? You know? And in any other way we are relating with employees, is fairness, and even the policies we are coming up with and how we are implementing them. Is that consistency? Yeah.
Great. That is actually what fairness means. It is to ensure there is consistency. We are treating people equally. We are looking at things legally, administratively, and we are also giving them a fair opportunity to be heard, giving the proper, there is no malice in it, or there is no witch hunt into it. So when it comes to fair administrative action, it means all the administrative action that are being taken against a person, be it by any authority, that it could be even by the judicial authority. They have made a ruling, like in these cases. So they have taken an action and given an order. Maybe they have said you must do this, or they have declared this and made a decision. So any decisions or an action that is being made against a person, it must be fair in all the aspects. And we look at what are some of the parameters we have in administrative action fairness. maybe the speed of how we resolve these issues, how much time do we take. That is why you can see even for judicial officers, if a case stays in court for a long, long time, you can seek redress by maybe saying there's a lot of, it is taking a lot of time, there is non-cooperation, so you can sue for that. So fair administrative action against, when you come to the workplace, it also looks at the issues of taking an action against a worker or an employee. And we will look at different types of administrator. An employer now become an administrator. When they are taking a disciplinary action, what are the bare minimum that they should ensure? Should you just wake up one day and tell someone, come for disciplinary hearing? Or you just wake up and say you are terminated because you did this? It gives the whole procedural issues that when someone is alleged or is accused of, we say they're innocent until proved guilty. So you must tell them maybe in writing that you are accused of all the reasons, you give them under what circumstances, and you give them an opportunity to respond to those issues. Again, before they respond, you cannot give someone a letter today and you tell them you respond in 1 hour's time or by 12. You need to give them ample time to prepare their response. Again, if you are to call them for a disciplinary hearing, you cannot just wake up and tell someone, come for disciplinary hearing tomorrow or in the afternoon. You need to give them enough notices, sufficient time to prepare. If they request for some information, you should be able to give them. It is their right. So you'll see, we will actually go through this document because probably many of you have not used the document or have not come, because for us, majority of the HR, we concentrate on the 5 labor laws or the Employment Act, but this is also contributing very much in terms of the labor laws. So it is a very short document. It is which is called the Fair Administrative Action Act of 2015. So you can see it's pretty new. And if you Google, you'll get it. And it's about 50 pages document. So I've tried as much as possible to summarize the whole document and what it is providing for in terms of about 15 slides so that we may understand. I was not able to actually do the very key highlights like the way we did. And that is why it's a standalone, because the Employment Act, we've been working with it for many, many years, but this might be new to us. So I have just dissected the document, picked a few clauses, actually majority, 3/4 of the clauses, which is more relevant for our understanding. But after this, I would recommend that you download the document, you understand it. Among the documents that you're going to bind, ensure you have the fair administrative action, because when you're looking at the termination issues or the issues that go to court, mostly they are based on, you may have a good reason, but the procedures were not followed, or if they were followed, they were not fair. So you can have done all these things right, but there was no fairness in the decisions that were made or any action that were made, and someone goes to court. And out of that, they declare the decision null and void. So you can imagine it is a whole disciplinary you went through, but because you missed or you didn't give a fair hearing, you did the disciplinary hearing, but because the hearing was not fair, or the representation, or there were documents that were not shared, it actually renders the whole process null and void, and that they'll say it was an unfair termination, and you know what are the repercussions of that. So we will move and look at it. So we will just listen as we were doing, and then from there we will take questions. So in terms of the introduction, we are saying an administrative action means that an act or an omission. So you can act or you fail to act of an administrative or legislative nature, and include any acts or omission of an administrative that is done or omitted in the course of all, in the auxiliary to all, preliminary to subsequent judicial proceeding, maybe for civil or criminal cases. What it means, it can happen before an action is taken, in the course of taking the action, or after taking the action. That's what it means. And it is applicable to all the civil and the criminal cases, whether it is against the criminal cases. We say they are cases against a state where someone commits a crime. And those normally are done by the administrative authorities like the police. So it is you against the state, or it is mostly the state against an individual person, maybe who is maybe breaching peace of the public. So it is to the public interest. Those is what to the state's interest. So those are the ones that we call the criminal cases. For civil cases, we say it is just a relationship between one person, one party to another. It could be a person to another person, a person against an institution, a person against someone, another party. Even those are what we call the civil cases. So most of the labor issues fall under civil cases. So then there is a case law of Marbury and Madison it's a very old case of you'll be surprised how law goes back to very old cases. So this is the case of 1803, but it has remained as one of the most significant cases that it has not been changed. And actually what it brought out is the constitutionality, or maybe the supremacy of the Constitution. And all the people who used this this law, including Kenya, it is a case that you'll keep on seeing being made reference to. Actually, if you look at even the BBI, you will see a citation of that case because it has never been challenged since then. So this is a case of that was decided in the 1803, and it has remained important in America Constitution, which we also borrowed from and will keep on making reference to. So we are saying in this case, it was a landmark US Supreme Court case. So you can see it went to the highest court of the land because it was involving the interpretation of the Constitution and where the decisions that had been made by the Court of Appeal that they were upheld. So what happened to this case? It was a judicial review, meaning that the American courts have the power to strike down laws, even the statutes. And in fact, you'll see how it is being applied when we come to our case law. And so some government actions that they violate the Constitution were declared null and void. So what had happened in this case, it was a case of an outgoing president and an incoming president of America. So we had President John Adams, who lost to Thomas Jefferson. And just 2 days before President Adams' term was coming to an end, he belonged to the federal party. He actually decided to appoint a circuit of judges and some of the supporters that he had to state positions. So several of them, so that he's able to frustrate the incoming government of Thomas Jefferson. So he just did this 2 days before, and since he's in the government, the Senate went and approved the appointment and they took positions and everything. But when that is the 2 days before the exit and the inauguration of the new president. When the new president came on board, there were some still commissions that had not been executed of these appointed judges and the state officers when the new president came in. So when some of those, one of it was the Madison was a businessman. This is a businessman who had been appointed and a supporter of the federal party. Those commissions that had not been executed by the time the new president came on board, the president actually advised his state secretary not to honor them. And one of such cases was of this president now, one of this businessman called Madison. So he actually said, we are not going to execute, they are null and void because they are not going to be executed. All the ones that were outstanding, they refused to execute them. So Madison actually felt aggrieved and went to court, and the court actually agreed, and they said that they didn't find it in any purpose to actually execute them. It went to the Court of Appeal and it went to the Supreme Court. And actually, so they were looking at some pronunciations that had been made by the Chief Justice, an opinion. The Chief Justice had made who was called John Marshall then, had made an opinion that it was normally proper for a court that in such situation to order the government official in question to deliver such commissions that were outstanding. That was just what we are saying. It is an opinion of the court which had been made by the Chief Justice then. However, when the Supreme Court was looking at this case for Marbury, now Marbury, they actually did not order Madison, who is the state secretary, to comply. They said by examining the sections of the law that the Congress had passed, that those were the people who are passing, it's like the Parliament of Kenya, it gave the Supreme Court the powers beyond that were originally set down in the US Constitution. So they said the laws they had passed in Congress, the Supreme Court had the powers to actually do away with that and uphold the supremacy of the Constitution. So that is how the case ended. And at the end of the day, actually, the court said they didn't have the mandate actually to issue such judgments against the state. So this is a landmark case. And since then, it has never been challenged, and it has become a case of reference in a lot of rulings and a lot of judgments that you will see, especially when you come to the constitutionality of maybe a state statute. If you check that case, you can always get that case. The other thing is, if you just copy Marbury versus Madison of that case, just the way it's coded, go to the internet, Google, you'll download the whole case, and you'll be able to read when you get you have more time to do that. So let's look at the Constitution of Kenya. The Constitution of Kenya, what does it say? It says that every person has the right to administrative action that is expeditious, that is efficient, that is lawful, that is reasonable, and procedural, fair. So it is a constitutional right for every individual that before an administrative action is taken, all these parameters must be met. It must be expeditious. It should not take forever. It should be done within the proper time. That's why you see, like when you have the cases of, I don't know whether this is still happening in government, someone has been interdicted or has been in suspension. Can you be on suspension for 3 years in government? Does it still happen? I know before the Constitution could even be on suspension for 3 years. But now when you go to the CBA negotiations and our policy, we normally give a timeline that you cannot be for more than 3 years, for more than 3 probably months. And for you to be put on interdiction, this must have happened. You must have been told the reason why you are being interdicted or you are being suspended. There are people who go ahead and say, they actually give who can suspend who in the CBAs. Like where I work from, the union, what they have negotiated, that before any suspension is done, the due process must be followed and you must have been heard. You cannot be suspended before the disciplinary hearing has been done. It depends with how you have put it in the CBA and also in the policy. Again, one thing that they have put different also from the government, that they take interdiction not as a disciplinary action. They have taken interdiction as a disciplinary process, that you can be interdicted pending investigation. You don't have to have had for you to be interdicted. It becomes a process that if you are suspected and you get the show cause and you are given the reason and why and the suspicion and the allegation, you are given an opportunity to respond to those allegations. But since they want to do the investigation, you have to step aside from your desk to facilitate investigations. So there you become on interdiction, and they'll give the parameters that when you're on interdiction, probably be on a half pay or no pay if it's the issue of desertion of duty or the issues of fraud. But for suspension, then you go without pay, and that can only happen after the hearing has been done. So it varies from company to company how the provisions of the policies are, because if you look at the issues of suspension and interdiction, you'll not find them in the Employment Act. Are they? They are not there. So mostly they're in the policy. If you go like to the Government Public Service Commission, HR policies and procedure, the generic one, the policies are there. But actually, even what the public service says, then you tailor your policy to reflect what ideologies you have in the organization, and they must be lawful and valid. So we're also saying any disciplinary action must be efficient, cost-friendly as possible. That's why we come up with the issues of conciliation, arbitration, issues of mediation, because we understand the adversarial court systems are very expensive. Then any action to be taken, it must be lawful. You cannot purport to take an unlawful action because you had a good reason. That maybe probably I'll give the case of the criminal law, that because someone killed your son, now you think you have good reason because you are aggrieved to kill that person. The action itself is unlawful. Reasonable in any manner, and it should be procedurally fair. Then the other provision we have in Article 47, actually this Article 47 is what gave effect to the statute that we are going to look at. If a right or a fundamental freedom of a person has been or is likely to be adversely affected by the administrative action, the person has the right to be given written reasons for the action. It is written reason. Someone will not come and tell you verbally and tell you step aside verbally. So everything must be in writing, and it is a fundamental right and freedom that cannot be taken away. These are the non-delineatable rights. Then we say Parliament shall enact legislation to give effect to the rights of clause 1, which is above there, and the registration shall provide the review of administrative action by a court or an appropriate or independent or impartial tribunal, and shall promote effective administration. So it is against this constitutional founding and premise now that we came up, actually the Parliament came up with the Fair Administrative Action Act of 2015. So this is an act of a Parliament, and we will go section by section for the things that actually relate to us as the HR. So you will just move on with me. Part 1 of this constitution, I wish you had downloaded it or you had a soft copy so that we could follow. Part 1 is just on preliminary. What does preliminary means? It actually gives the short title. When you are referring to this document, what do you call it? If it should be referred in all contexts as Fair Administrative Action Act of 2015. That is the name of the act. So that we don't say we have the fair law. Just like the employment, there is nothing called employment law. It is the Employment Act of 2007. If you look at the preliminary of that statute, it tells you how is the statute referred to. So it has the short title, which is the Fair Administrative Action Act of 2015. Then section 2, it is just on the interpretation, and it defines what an administrative action is. It has various actually definitions. So it defines who is an administrator. It means a person who takes an administrative action or make an administrative decision, someone in decision-making power who can make an administrative action. So in this case, even the managers and an organization becomes an administrator. It talks about when they refer to the cabinet secretary, which cabinet secretary are they referring to? They also refer what is a decision. And they also say what are the empowering provision, what is the failure, what are the state organs, and what is a tribunal. Those are the definition it has. So the ones that I picked specifically for this case, it is what is administrative action. I had asked that. And it say, unless otherwise, in another context, administrative action will include the powers, functions, and duties exercised by authority or quasi-judicial tribunals. Quasi-judicial are not the cost, they are the other, we call what, subordinate judicial systems like the mediators, the conciliators, the various tribunals that we have that we can normally go through before we go to court, or maybe where it's provided, it is a matter that is within a tribunal, not within the mandate of the court. Then we are saying it is also any act, listen very carefully, omission or decision of any person, body, or authority that affects the legal rights or interest of any person to whom such action is being taken. This is material action or even adverse action. Like if someone is losing a job, is going without a pay, those are actions or decisions that is affecting the fundamental right for that person because they have a right to maybe fair working conditions and a fair remuneration. So section 3, it is just on application and falls under part 1. So it says, it's still under part 1. No, it's part 2. That's the beginning of part 2. So section 3, the act applies to all state and non-state agencies, so that you don't say an employer or an organization, it's not an authority. So this act is applicable to state. So both government and non-government agencies, and it includes any person who exercise administrative authority, any person performing judicial or quasi-judicial functions under the Constitution or any written order or law, whose action, omission, or decision affects, that's saying any person whose action, omission, or decision affect the legal right or interest of any person to whom such action, omission, or decision relates. In terms of the fair administrative action, section 4, subsection 1, it says every person has the right to administrative action, which is expeditious, which is efficient, lawful, reasonable, and procedurally fair. We had said that. Then section 4.2, it says that every person has the right to be given written reasons for any administrative action that is taken against him. So any action that is taken against an employee, it is the right of an employee to have that action communicated and reasons given in writing. You saw the recent ruling about terminating an employee on probationary review, that we don't want to confirm this person. We just come and say, following the probation review, we have decided to terminate your probation contract with immediate effect. The court has ruled that you must give a reason. And before you even take that employees to terminating their probation contract, they must be heard. They must be given an opportunity to be heard, because why are you terminating? Is it on misconduct? Then you give the reasons and the evidence. Is it on performance? Then you are able to give the reason. You hear him probably. I've seen like a lot of people have lost jobs because they were on probation and Corona came, and probably they were in marketing or sales, and it was no longer possible for them to go out to the market because the market was closed and sell. So were the reasons within the control of that employee? That is what now the procedures and the hearing and the opportunity and actually lawful reasons demands. Then we go to a continuation of that, section 4.3, it says, where an administrative action is likely to adversely affect the rights or fundamental freedom of any person, the administrator shall give a person affected by the decision the following. It is not may. The wording of that statute or that provision is shall, so it is mandatory. It is not negotiable. So the administrator should give prior and adequate notice of the nature and reasons for the proposed administrative action. So even before you terminate, before you take action against me, you must give me the nature or the circumstances and the reason of the proposed action. An opportunity to be heard, as Patricia said, and to make representation in that regard. So representation you can make in writing. You are given a show cause letter, you respond. Again, you go for the disciplinary hearing, you give your defense, and also you can also be represented where it is necessary by maybe an expert or a union representative. Must give notice of a right to a review or internal appeal against an administrative decision where applicable. This is where you see when you're taking a disciplinary action, probably you want to give a warning letter. It is always good that you include that clause that this administrative decision has been taken by the board or the management. However, you cite in the policy provisions that you have that any employee has a right to appeal their decision. And you see, you appeal to a higher authority. So if it's the CEO, you can appeal to the board, or I know we have those appeal provisions in our policy. So you can still appeal. And if it's probably even a termination or you have separated with an employee, as you give the summary dismissal termination letter, ensure that you include the clause that there's a provision for appeal, so that you'll see some of the cases that go to court, they'll say you didn't exhaust the administrative maybe mechanisms that were there, because probably you could have appealed the decision internally before you move to court, or you could have gone to a tribunal, or you could have gone maybe to a mediator if those provisions are there. So it is a right for someone to be given the opportunity to appeal against such an administration decision. Then a statement of reason pursuant to section 6, which we will look at. Then notice of the right, that is section 6, it talks about the right to give the information that if it's an investigation report that is being based to make a decision, then there's that provision that you can ask in writing for that information, or you have the right to be given all the information that actually the people who are making decision are basing their decision on. And in part 6, it will even talk about the issues of if it's something about a public office that you can write, and this information must be given to you within 30 days. And failure to give that information within 30 days, it will be deemed that the decision that was taken or the action, it is null and void, because there are no reason and you have not furnished the information. Otherwise, if there are any extraneous reasons that makes the administrator not be able to give that information, again, within that timeline, they should be able to respond to the person being affected by the decision in writing the reasons why they cannot furnish that. And actually, that is mostly you'll ask for that information when you want to do an appeal. So to enable you to do an appeal, I want to see the evidence or the report or the investigation report that was used. You'll see, like when people are coming for disciplinary hearing, the union will always ask for, give us the investigation report. They want the full file of what the disciplinary committee is going to base their argument and the hearing on. The other issue, we also make sure when someone appears for the disciplinary hearing, the copy of the show cause letter was given and their response. We normally show them and tell them, can you confirm this is a true copy of the show cause letter that you received? And he said, that is the letter that I received. So that even the members of the objective independent members sitting in that panel, the person who is being heard, they will have the confidence that the letter that I was given and the content, it is what these other committee members are using. Again, the responses they gave, it is always good, because you can also find yourself in that. We are not beyond this. The responses that you gave, you are also shown, is this a true copy of the responses that you submitted, or there is something missing? And I'll see the person actually going through the responses, if it's many pages like 30, to ensure whatever has been filed to that committee, they are actually 30 pages, because a malicious person can decide this page 6 or page 30, it is not sitting well with the management, so I can pluck out that page. So even the people who are sitting to do the disciplinary hearing, so that they don't come across that information, always satisfy yourself or give them the opportunity to actually see. And then you mean it, you say, during the disciplinary hearing, the person, maybe the accused, actually was given an opportunity to confirm that what has been filed is a true copy of the materials, and that is what the committee members were using. Then notice of the right for legal representation, where we said applicable, especially when you're dealing with the union. Tell them you may be accompanied by your union representative, and ensure that you copy the shop steward or the union representative to such invitations and all the communication you're dealing with the employees, so that they're in the know. Then notice the right to cross-examine where applicable. It is under right of the person whose action is being taken, probably in a disciplinary hearing, if they want, just like to cross-examine a person, especially when those things are in the policy, it is their right, and you cannot actually deny them. They may ask, I want to cross-examine, or I want this witness to be present, and you can imagine if you decline such an opportunity, which has been given in the Administrative Action Act, saying it's not in the Employment Act, then that could be the only maybe reason that someone could actually go to court and say, I was denied a fair hearing. If actually I decide where it is applicable, I want to come, even in new management, someone who has evidence, I want to come to be accompanied by my colleague. Let's say this is the head of HR, or maybe the HR director who've been subjected to a disciplinary hearing before the board. And probably there is the finance director, because you've been accused of fraud, who understand the system better. And you want them as a friend to accompany you. You have a right, and they cannot say no. If they say no, then that becomes a gap, and someone can exploit and take to court after an administrative decision. Information, material, evidence to be relied upon in making the decision or taking administrative action. Remember, we said shall. So there are these are rights and freedom that you cannot deny to an employee. Then a continuation of that, section 4.4, the administrator shall, again shall, I've put it in bold, accord the person against whom administrative action is taken an opportunity to attend proceedings in person or in company of an expert of his choice. You cannot say because you're not union, I cannot be a company. Of course, some policy provisions that you'll ensure you'll pick is like the legal, you see, like the legal counsel or the HR, because they are, if you look at maybe how you constitute your disciplinary panels, who are the members of the disciplinary panel? For us, they'll say the mandatory attendees, the HR must be there, in charge of HR, and the legal. So the HR will come to give the HR technical expertise, and maybe the company secretary, the head of legal, will give the legal opinion to that committee. So if actually then maybe I'm the head of director HR is the one, then they will substitute with someone else. Maybe that will go to a board level. Let's say we are subjecting a person like the finance director before a disciplinary committee, or a finance manager in that case. And the friend and the person who have the evidence would be the company secretary. We put it a rider in our policy that since the company secretary and the head of legal is the internal legal counsel who is expected to give the legal opinion and technical advice to the management, then those people cannot accompany you as an expert. But if they have a conflict of interest, they have the right to declare, I'm conflicted because this case is affecting Rhoda, who is my close friend. We have those declaration of conflict of interest before. If actually the person who is likely or who is facing a disciplinary action or administrative action says, or maybe it is my staff in HR, this is my direct supervisor who is my accuser and my complainant, that person is conflicted. I can request that person to recuse themselves from that disciplinary sitting because they'll not be objective. If I request that, it is a right and it will be given. If they refuse again, you'll not push, but you know that becomes a weak point because there was no objectivity, because maybe the accuser becomes what now Patricia was saying, you are the complainant, you are the prosecutor, you are the judge, and they are jury. That brings a conflict of interest and objectivity of that committee. So they also have a right to be heard. I said cross-examine persons who give adverse evidence against him or her. Of course, it uses him, but it means both, and request for an adjournment of the proceeding where necessary to ensure fair hearing. If I actually come to you invite me for a disciplinary hearing and tell me within 3 days, but I fear the policy should have been 7 days and maybe the kind of preparation I need is a lot, I can request for an adjournment to give me sufficient time to collect my evidence and to prepare myself adequately. And I do that in writing, and that it is a right. If I attend a disciplinary hearing, and probably because of the circumstances here I'm overwhelmed or I'm unwell, it is your right to request for an adjournment for the proceedings where necessary to ensure a fair hearing. So when those requests might come, you might just see someone after just 1 day before the disciplinary hearing, not given ample time. They say because of this, or they bring a sick off. Those are not things you take on a person. You try to be fair as possible and then accord them another opportunity. So administrative action affecting the public, this is just for our knowledge, because we've had cases of where there is public participation, or a governor has taken an action, or someone in public, or even the police, they have taken an action against the public, and how was it done? So before a public office maybe takes an administrative action against a person or a citizen, the following should be followed. So section 5.1, it says, in case where any proposed administrative action is likely to materially or adversely affect the legal rights or interest of a group of persons, it could be an estate, a school, or the general public, an administrator shall. That's why you see now office of so-and-so writing maybe to an institution, to actually a person, or writing it on the newspaper that we are going to close this road, we are going to do this. This is where it falls. Issue a public notice of the proposed administrative action, inviting public view in that regard. Should consider all views submitted in relation to the matter before taking the administrative action. Consider all relevant and material facts. Where the administrator proceeds to take administrative proposed action in the notice, give reasons for the decision of administrative action as taken. We are going to close this road because they are going to have a marathon, or we are going to do constructions. Issue a public notice specifying the internal mechanisms available to the person directly or indirectly affected by his or her action to appeal, and specify the manner and period within which such appeal may be lodged. That's just for public. Then just a continuation, part 2 of section 5, it says, nothing shall meet the powers of any persons to challenge any administrative action. It is a right to challenge. Nobody is limited that you cannot challenge. If actually someone takes a harsh administrative action against me, and I feel it is adversely or materially affecting me, it is my right to challenge that administrative action, either internally or in court. All decision in accordance with the procedure set under the Commission of the CAJ 2011 or any successors to that provision of the Act. Then apply for review of an administrative action or decision by a court of competent jurisdiction. That is, it must be within the mandate of that court in exercise of his or her right under the constitution of any written law. So that is why you can see even an employer can make a harsh administrative action, not necessarily terminating you, but you take them to court for a judicial review, or maybe to stop them from further violating such. Institute such legal proceeding for such remedies as may be available under written law. We are going to look at various remedies and judicial reviews that are available to a person who an administrative action has been taken against. What is available for you as remedies in court. Then request for reason for administrative action. Section 6(1), it says, every person materially or adversely affected by any administrative action has a right to be supplied with such information as may be necessary to facilitate his or her application for an appeal or review in accordance to Section 5. Actually, like what I see the employees will do, if a decision is made against you, you write a formal appeal, and maybe because there is a conflict of conflict of interest of people are already made up their mind, they will proceed with that. They will quickly respond to your appeal and say the earlier decision is upheld. Probably not even go to the board level and someone just sit like the CEO and they make that decision and they respond to show they gave you an opportunity to be heard and we responded to you. However, at that point, you can also demand for information that the administrator is based to make their decision for purpose of review and appeal application. And now they'll be bound by that and they must give you. And if they don't provide you, you can proceed to court and say, I requested, and you have those written, but they declined to give me because there was no sufficient reason. And you can see if that information is not provided, the decision can be the decision or action or mission was null and void. Section 6(2), it says, the information referred in subsection 1, that is 6(1), may include the reason for which the action was taken. Yes, there are 7 allegations that had been leveled against me. I had 6 charges in the show cause letter. So for the final decisions that were made, what were the reasons? Were they 4 out of 7 or were they 1 out of 7? Which particular reason actually led to that action or decision? Any relevant documents relating to the matter. But for good practice, even by the time you're doing the final termination letter, you'll say you are charged with 7 things. However, we found you guilty or culpable of charge number 5. So now I can demand on that charge number 5 to be given information, the investigation report, and the evidence that was based to make that decision. So request for that as a continuation, we are saying section 6(3), the administrator to whom a request is made under subsection 1, which we have looked, shall within 30. Of course, what I've added in those brackets is days, because even statutes have errors, because if those days is not there. So if you read within days after receiving, within 30 after receiving request, I think there is an error. It's a typo error in that statute. So it's within 30 days after receiving the request, furnish the applicant in writing the reasons for administrative action. Then part 4, it says, if an administrator fails to furnish the applicant with the reasons for the administrative decision or action, the administrative action or decision shall, in any proceedings for review, whether a court or internal for such action or decision, and in the absence of proof of the contrary, be presumed to have been taken without a good reason. because you're not able to give the document and the support, then there was no good reason to take the action. So subsection 5 says an administrator may depart from the requirement to furnish that requested reasons if it is reasonable and justifiable in the circumstances, and shall inform the person making request of such departure. Maybe the information is so confidential and it's likely to cause more damage to the other employees if released. So you see, at least as an employee or an employer, when you're at that point, you have tried to cover. So it will not be that you refuse to give. It is because of, it is better for the court to say the reasons that you gave for not furnishing were not sufficient. So they can also order you to furnish. You see, there is that timeline. That's how now the advocates play about their games. Yes, I know by law I'm supposed to give, but if you have justifiable and reasonable decision, now those are some of the clauses that actually the law, our learned friends will actually exploit. You see, when you say reasonable and justifiable, it's neither here or there. It is like fair remuneration. It will say, in my belief, or the belief of an organization, now I'm talking as a HR, the reasons were reasonable and justifiable according to us, but were they justifiable to the other person? So those are the legal minds, theatrics they normally see, and that's why you will say, nobody will say that the law is very clear. They exploit. Those two words can really be exploited. So for you as a HR, if you're HR director or HR, for me, if you feel or there are challenges of giving that information, it is only prudent you respond to that request within those days and you give some reasonable or justifiable. But actually, if you're looking for the welfare, because you can also be on the other side, it is good that you provide for that. Don't be the one to actually be the hindrance to people getting justice and their freedom and rights. Statutory orders for review. So these are the things that I was saying. If you are to apply for a review in court or a tribunal, mostly this happens at court level. What are some of the remedies that are likely to be worded or you can pray for in court if an action has been taken against you? So you'll also look at how this is applied in the case law, especially the one for the ruling, where a union actually went to court to sue an employer for refusing to sign a recognition agreement, citing they had the critical mass of 50+1, and saying people had signed, but now the employer was saying they didn't have the numbers because maybe according to them, the numbers they gave to court were different. So you'll see some of the remedies you can go seek in court. So the first remedy that you can apply in a court of law is the declaration. And what we call declaration? A declaration is a formal statement by court that an action or a decision is unlawful. You go to court and say, the decision that has been taken against me was unlawful because it violated, you must know the law and the clauses. That's where now the work of the lawyers come in. When you apply for a decision or an action to be declared unlawful, it is not a contempt of court because they'll just declare this action by the government. You remember, like the BBI, it's unlawful because it came from. So there was nothing that the government, it is just to stop and say, whatever you did, it is unlawful, and now it becomes null and void. It's not a contempt of court, and I will show you how. If you ignore or defy such a declaration, because you know an action has already been taken. So you have declared, I terminated this employee, and I want to declare that termination unlawful. What are you supposed to do? Of course, maybe the court will award compensation up to a maximum of 12 months salary. And then that is it. You're not supposed, but unless there is a specific prayer that now you are given, which now was in another category, that you reinstate this employee, that is not now a declaration. There's a certain order that has been given. So then mostly in many cases when such declarations are made, the government or the people will just ordinarily comply with the declaration. You see, when the court pronounced themselves and stopped the BBI, the government had just to stop. And they just complied with the requirement, and then you study, probably you do an appeal. Number two, an injunction. When a court gives a court injunction, it is an order that something be done or some action taken. It is actually a mandatory injunction. You are compelled to do this. so that an administrative body ceases or refrains from doing an act. That is it's either a prohibitive or a negative injunction. So if you're prohibited from doing this, you cannot continue doing it. If you continue doing it, it becomes a contempt of court. If you're told to do this within this particular time and you don't do it or you disobey, then it becomes a contempt of court, which is another offense. So we have clearly understand what is a declaration and what is a court injunction. Then the other statutory orders or the judicial review orders we have is what we call mandamas. How many of us have had, I'm applying for mandamas? You know, these are the things we learn on the training. In fact, those terms I learned them when I was working with IPOA, and because we were dealing with a lot of lawyers, we had 10 like them. And then when you have to sit in an interview to interview director investigation, head of investigations, then you had to really understand this because we were dealing with the cases of homicide. So mandamas is just an order by court requiring an administrative body to perform an act and make a decision. So someone is to be compelled, mostly a body, an administrative body, they are compelled to do something. So you apply for mandamas. Then there is what we call, these are Latin terms, certiorari. It's an order that quashes a decision that has been made unlawfully. And maybe a court of, you can apply through a petition probably to a court of appeal that a decision of a high court, it is quashed. A quash is done away with. Yes, a decision was there, but we want that decision done away with. That is what we call certiorari. Then when you come to prohibition, prohibition is purely prohibition. So you can apply. And once the court makes such rulings, those that comes in the form of ruling, that is done. An order requiring a body to cease proceedings because it lacks the mandate or the jurisdiction or has exercised its jurisdiction improperly. It is the appropriate remedy when the proceedings are not only partly completed, or it prohibits the body from proceeding with that because it's not within their mandate. Let's say like an employment case. I've gone to apply in which court? In environment or high court. You cannot take an employment matter to high court straight. It is because they don't have the mandate. Even when you file those applications, then they'll be quashed. Or you go to a tribunal which does not have the mandate to handle such cases. So you can apply for prohibition that prohibits that body from proceeding with that matter. This could also comes up like when a case in court, you hear anytime the public government officials are talking or any investigative body, they say, like even the DCI, they cannot comment on the matter because it's in court. And if actually they keep on commenting or even writing about that matter, you can go to court and prohibit and apply for a prohibition that they are compelled to stop doing that until the matter, and then it can become an offense. In the common law forms, we explain what is the common law. These are the laws and the British customs that they used to do, and they were all just under the doctrines of equity. So the last three, that is the mandamas, certiorari, and prohibition, are normally prerogative, or what they used to call them as writs. Writs means they were informal courts that people used to go. And when a judgment you'll just go put your petition and the judge will just write on a piece of paper and issue judgment, and you go and serve the other person that order, what they were calling as writs. That's how they were calling them, writs. Have been the traditional remedies used against unlawful administration action by the common law countries. And in conclusion of all that, I've come to being able to summarize that page, the 50 page into those. We are saying the clear intention of this act, it is to have a regime of rules made by the Chief Justice governing judicial review of administrative action, and it provides that the Chief Justice may make rules of practice for regulating the procedures and the practice in matters relating to judicial review of administrative action. And most of these cases, the rules that the courts will make, they are filed under certificate of urgency. They call certificate of urgency, that you want to go to court and you want to be given priority because you need this stopped. Maybe the auctioneer have advertised they want to sell your house and you rush to court and you want to give those judicial review and give a ruling so that they don't proceed. So they are filed under the certificate of urgency. Those are some of the rules that the court will come with. Then we have the CAJ, or what we call the ombudsman. I'm sure you have heard about the ombudsman, especially those who have worked in the government. When one authority seems to be frustrating the other, and it's within their mandate to do that, actually you can file, before you even go to court, you can ask for the intervention of the CAJ, because CAJ, it's a constitution commission that is mandated to actually administer this act. It is the watchdog, or they call it the ombudsman. It plays a very critical role in handling judicial review and fair administrative action matters, including alternative dispute resolution. I've seen an organization, maybe you're trying to get the document from the Ministry of Land, they are not cooperating, you can do a petition through the fair administrative, through the CAJ, for them to intervene within their systems and mechanisms. So that's what happens. And that brings me to the end of the fair administration. How is it? Is it new? Were you aware of that provision? You can see how you relate it to the other many employment labor laws you have. Any additions, comment? Is it relevant?
It's more very elaborate and has sanctions, so very quite succinct. If you do this, or there's provision for, there is a cause and effect, very well outlined. And if you now look at this, I'm actually looking at a situation where you have your disciplinary policy, and then you need to review it with the provisions of the Fair Administration Act, in it, because the disciplinary policy borrows so much from what the Employment Act 2017 provides. But now when you look at what the administrative, you can now see what will guide our actions as the administrators. So to me, I have actually a call for action. My policy on disciplinary action has to really incorporate the provisions of the Fair Administrative Act. And I didn't know it's 2015. I actually thought it's a very new law. Look how we just, imagine. And with this, even our disciplinary processes we would be managing, we will be doing the best before we escalate some of these cases to the, labor relations via courts. So another, again, calls for reading and mastery. I think HR, and I'm not surprised that you are taking up, studying law. I'm a bit inspired to follow you, because you can't have this. In HR, we are doing more the administration, and we're not looking at the possible litigation, those gaps that can easily expose the employer and even the professional as the HR who is in charge. So my experience also is when we're doing disciplinary, many a times, before you go to the hearing and so on, you have to read, you have to really find out what is relevant and so on. And we apply this, we kind of guide even the legal team. The legal counsel really relies on us. I've realized when you leave it to them, they don't get the context. But now for HR, and even now where the unions are, if we can marry and really, close in any loose holes, any gaps, then we can be able to guide our staff where there is conflict, there are complaints and all manner of disputes. So to me, it is an eye-opener, and I'm really, really, really grateful that we have provision that can actually, sometimes you take action and you're not sure what is my, where am I drawing my powers from? You need the backup. And if it's in the law, then it's good enough.
Actually, Patricia, I hear you, because some of the frustrations that the HR has gone through, especially for me who has worked, like I can tell you in IPOA, you could go for, and we have a panel of like 5 lawyers, and you are the one. So even though you were to go for a disciplinary and you have to take case to the board, it is you versus the company secretary or the lawyer. For you, you are looked as a general practitioner, layman. So when that legal
Yes.
person speak, whether they are speaking on misguiding, and you know they are misguiding because you partially know the law, but you don't have that authority to say, I'm an advocate of the High Court.
Yes.
I'm trained in this. So you are just,
Yeah.
you end up just taking, but you know you have misguided them, but you don't have a voice. And apart from
You
doing
see-
your everyday job, what if you are to specialize in just that and maybe representing those people? Those are some of the things that I actually looked at. So when I look at Employment Act and the other legislations we have, they have action and the statement and the policy guidelines of what you can action. It tells you, if you don't do this, I can terminate. If you don't do this, I can. But the procedures, if you look at almost the labor cases, they are falling on grounds of not following procedures. And then when they come up with those procedures, they are not even in the Employment Act. And then the legal person will tell you it has not expressly stated.
Yes.
Yes.
Yeah.
So
it
that is
not
where we are.
explicit, and it's very frustrating. Yes.
It is a very frustrating position to be.
Yes.
And I've experienced that. It's a shared feeling we have.
No. I hear you. I really hear you. It's terrible. In fact, as HR and maybe our colleagues there in the union, it's good they are on. The most frustrating function of HR is disciplinary. That is a week you need to take a lot of water. It is terrible. It's the most draining exercise, disciplinary, whatever level, because you'll get all manner of opinions. Yeah. So,
and actually, when you know your staff, again, the legal will start respecting you and having a conversation. But I normally see, like, even before we draw a show cause letter, we will have a lot of back and forth and discussions and argument with the legal until we come to that consensus and agree this is what we are going. We have even come up jointly and told the CEO, this is not a case to do a show cause letter because there is no evidence, there are no basis. Of course, at times it has led us into trouble because you can say you are just chasing weed. Maybe the people who are driving you to issue the show cause letters and take the disciplinary, it is to meet their other interests. But where are you?
Absolutely.
As a profession?
Yes.
So it is frustrating. It's also not a walk in the park because, again, it will also land you into a lot of trouble, but it's a trouble worth taking and a risk worth taking if you want to grow yourself. So thank you. So that is the end. And John, am I closing you out before we move to the ILO convention?
No, it's okay. It's more for you as HR to protect yourselves. For us, we are looking at it on the other side. We are protecting our employees, and therefore, for us, we have a weapon now.
I love that. I love this interaction of the union versus the management. That is why, Patricia, I told you,
it's a weapon. It's a good weapon.
For them, they see the loopholes. They'll just take the one statement
we need
on us.
Them. Yeah.
We need each other.
I look at them. I look at them as oversight. And like for private university, we need them like yesterday. Because that's the only, our second, that's the next army. You're there to protect the staff, but you need that army. Those who are not intimidated by, you are a member of management and so on. So union anytime. If you're doing the right thing, the union is just an oversight. It's a partner. There can never be conflict. Yeah.
Great. I love that. John?
Yeah, I'm also learning a lot, and I'd like to commend Patricia a lot from the discussions we've had in the last 3 days. She comes across as somebody who's who thinks about the staff, not just about the management.
Objective,
which is very refreshing, and it would be my hope that we could have more people like that in management and HR, so that it is not like it is me against you. It's like we are looking at what is right, and we are both actually there for the good of both the employees and the employer. Yeah, so I hope she will spread that to other HR people, because some of them are very vindictive. Yeah,
I agree. Patricia, where the management are beaten by the union, in terms of the capacity building, you see the way we feel about disciplinary, and we feel, I think if I had the option, I'll not deal with industrial issues. When it comes to the union
Yeah.
in terms of the capacity, they have actually mastered, and their training, they see any training that is talking about industrial relations, that is what we'll pick.
Mhm.
For me, I want to
Yeah.
go to balance scorecard, performance management, leadership, change management.
Yes.
So because they are easy and they are palatable, but this main very difficult topic, it is very good. And but when you are able to see from each other, it is such a very good cordial working relationship. And because we learn from each other and we build each other.
Yeah, and
Yeah.
I've also seen in some universities like Jaramogi Odinga,
Yes.
where both the management and the union, and this includes even the top managements like VC and BVCs, they annually have a training together on industrial relations and these kind of issues, so that they work together as a team. They are not always like one group against the other one. Yeah.
That's true.
Great.
Even those committees, like if you have the management disciplinary committee that deals with the disciplinary, you could sponsor them for training together with the union representative. Or again, if you have the HR committee, I normally make it an annual event that every year, the HR committee, because it will keep on changing, has to be trained on matters CBA, issues of labor laws, the legal pitfalls to avoid, all those ones. But of course, teaching is and understanding is one thing, and the interest is also another thing. That's what, because we might come and tell them the gospel, but when you go back to the office, it's through the window. So those happens, and just build capacity continuously, whether it's on an annual basis, it is very good. Again, at the board level, the HR committee, you could pick the leadership, not every union representative, maybe the chief shop steward or the highest at that level. Let them join the others, the management, the members of the HR committee. Take them for training for 3 days about this. Call FKE. The next time, call COTU. You can even now go to a level where now when you come to the CBA negotiation, you have an FKE representative and a COTU coming into to enhance the capacity of the both parties on mutual agreement. So let me not overemphasize the need for that. And let's now change gears. Thank you for the comments. And that is a confirmation that we were really following and absorbing what I was training on. So I will move to collective bargaining. Of course, collective bargaining, we've talked about it, and it's more deeper than this, but within the timelines that we'll have, we'll be able to just cover on a very high level how the CBAs are done and how they are really organized. So the CBA, the collective bargaining, we are going to look at the principles that are behind collective bargaining, the procedures, and also some of the practices of how people approach collective bargaining in Kenya. So those are the three. We are going to look at trade unions and trade unionism, what it is all about, which I think we really covered on day one, the first few hours of day one, when we were looking at the union, their functions, their structures, and how they operate, and their mandate, their visions, and all that we shared. We are going to look at what is collective bargaining in Kenya and concluding remarks at the end. So the trade union and the unionism, we are saying trade unions are what I've put in red, voluntary association of workers. And I say this would be a stimulating discussion. When we looked at the Labor Relations Act, is it still voluntary association of workers with the comments of agency fee? That's food for thought. The union is therefore a membership organization. We said it is owned, it is run and managed by members who are the union members. And the leadership only come to present them. Then we say the three key objectives of a trade union when it exists. This is just a recap. We said to secure. Secure is when you're organizing, you're trying to recruit, you're going for those collective bargaining, the discussion, you want to secure, whether it's the ILO convention where you're representing as the trade unions or the workers representative, you want to secure those welfare and the benefits and the fair working conditions for employees. So the first is to secure. You secure membership, you secure their interest, you secure their welfare, and you secure their security and benefits. Then to promote, once you secure, ensure you are able to sustain and promote further. So you keep on advancing and actually improving on it. You remember the decent work when we said how it started, then how it advanced, even being included in the Millennium Development Goal, again, further being included in the sustainable goals, going even to the specific targets. Those are how you promote whatever you have secured, and also to protect, guard jealously what you have acquired. You protect the interest, the welfare of the members, workers, and those of the bigger society through their families. Then we say the union operates under the agency principle relationship. What you are saying, the leadership of the union leadership are holding forth for the members. So it is the agent's principle kind of a relationship. And the key assumptions here is that the interest of the union leaders who've been elected by the confidence given to you by your members, it is homogeneous with the ranks and the files of your members. Are your ideologies, your focus, your mandate, or what you are doing, is it in congruence with the ranks and files? So the assumption under this unionism is that the union leadership is homogeneous with the ranks and the files of the members in terms of their interests. Number two, both the union leadership and the ranks and the files, those are their members, are maximizing the same utility functions, that whatever they get, they use it to the maximum for their general good of their members and their interest. Then some of the tools used by trade unions, we say there are many, and some of them that they normally use to discharge their mandate that we saw are like membership, organization, and recruitment. Much of their work that they do on the grassroots that we are not aware is not organizing, recruiting, and mobilizing their membership into coming, and those discussions you normally have at the grassroots levels, including the elections and the structures that you normally have. After all that is done, then they concentrate on management of the retention. Membership retention management is very critical for them, because if the members walk away from the union that you have really struggled to recruit, then it actually, it weakens the union in terms of voice, the power, the muscle to negotiate, that is weakened. And if actually the ratios go, or the numbers go below the critical mass, you might find now the livery of the other like union coming on board and being recognized, and maybe the recognition agreement could also be withdrawn, or the members could also vote you out. Grievance and dispute handling. Any grievances and disputes, at times I know some are even just managed the disciplinary at the union level. They don't come to management. How I've seen it also working, when you see some staff having some misconduct that are repetitive and you know they're likely to end up in disciplinary, I always call the shop steward and I tell them, I want you to send you to your member. I've talked to them, the supervisor has talked to them, but we are not seeing any significant change in your member. Maybe someone who is drinking, coming late, habitual latecomer, deserter of duty. The first thing I'll send a word to them, and I'll tell them, I'm sending you to your member. Go talk to them. At times they'll talk to them and these people will reform. If they don't reform, even by the time now we initiate the disciplinary action, even the union will come and say, we have really tried to work on this stuff with the HR, but we are not seeing change. We have had discussions, even tripartite meetings. You call the union when you're having those grievances and you come to an understanding. And by the time they leave the office, you follow with an email. Following our meeting in my office today, we have agreed on these reform issues. We hope to see improvement on your, so that you can be able to track. And you're doing it in good faith and in good heart, because you want them to change, or maybe for them to dig out, are there social issues that we are unable to go into, or can you support them in this way? Then the other instrument they use is the collective bargaining, and also the dispute arbitration that we talked about. Then let's look at trade union and the issues of the collective bargaining. And we want to see how this has been recognized in the Constitution. Again, I said we covered this a lot yesterday, so I may not re-emphasize. We said in terms of the Constitution, that the recognition of this, the rights have been conferred under Article 41, Section 1, which is on fair labor practices. We talked about Article 41, 2A, fair remuneration. You can see that is how it has been translated from the ILO. Look at the wording, it's fair remuneration. When you go to the ILO convention, it will talk about equal pay. Then Article 41, 2B, it's talking about reasonable working condition. Then joint participate in the trade union activities. That is 2C of Article 41. Then similarly, we have the rights of the employer. You remember Article 43, and also the socio-economic rights. Then the Constitution advocates for decent work with adequate income, representation, and security of social protection. Now you can relate when the Constitution just talk about adequate income, representation, and social. You remember the 4 pillars on the decent work? This is where it borrowed from, which actually was initiated in 1919. And you can see now it has been brought fast forward to the Constitution 2010. Again, in terms of the CBA and the welfare and the labor improvement of the workers, it was also picked in the medium-term plan 2 of 2013 and to 2017. I hope now most of us are in the government, you understand what MTP2, MTP1, 2, 3, and 4 means. These are medium-term plans that are actually put in place by the government as the operational plan to operationalize the Vision 2030. So they break them into 5-year slots. So we have what we called MTP1, which was ending in 2012. Then we have NTP2, which is 2013 to 2017. Of course, we have the current one, which is the medium-term plan for 2018 to 2022. So in terms of the plan that has just ended, which is MTP2, it prioritizes development of wage policies and finalization of the productivity policies. And what that means, the MTP3 is just building on the gains that were made in the previous MTP2 so that they can still continue promoting and enhancing the members' issues. So in MTP3, when I looked at the document, they say this is the third. We call them the first, the second MTP. This is now the third MTP. The third medium-term plan for 2018 to 2022, it is prioritizing issues of the policies, the programs, the projects that generate broad-based inclusive economic growth for the populations that we have, as well as faster sub-creation of jobs. We've been talking about unemployment, reduction of poverty, and also inequalities. And it's taking into account the meeting of the 17 you remember the Sustainable Development Goal? We said now there are 17 from the 8 that were in the medium development goals of the African Union Agenda 2063. I want you also to go and Google what the African Agenda 2063 means. We have Agenda 2030 for Kenya. Then for the African Union, it is Agenda 2063, which we have also borrowed some aspects of it. It's also good that you Google. Those are some of the documents. You just build your capacity and know what is happening to our economy and how the government is supporting. Especially when you look at those reports, they will give you what the government plans, their targets. They'll also give you, when you come to the next one, the review of how we performed in 2013, 2017, some of the activity, the socio-economic, which department and what did, how many Huduma centers were open, how many jobs were created, how many women, how many free medical facilities and were given to the public civil servants, how many allowances and what rates were reviewed. It's a very elaborate document. So it will give you from where we are coming from MTP1, 2, 3 to the third one. And especially those who in the government who normally go for those budget MTP discussions, you will see where your organization sit in the whole Agenda 2030, in the plan, and how it's also relating to your role in HR. We said for you to understand HR, you have to look at the whole context of how it is affecting the whole Government Vision 2020, the Sustainable Development Goals. You might just go for an interview, or maybe as you interact, someone asks you that question, where do you plug in the SDGs? Then you start asking, what are SDGs? How many are they? Which are they? So you can just download the 17 of them so that you just keep yourself with update and abreast with the trending and the economic developments of this country. So what is CB, what is collective bargaining? I want to hear from the union. What is collective bargaining in your own understanding? John and Anne, what is collective bargaining? Tell us what happens and what it is and what is the expectation.
Collective, from the word collective, it means the parties come together and they make an agreement on issues that seem to be contentious in the workplace. So there seems to be conflict generally between employees on one end and management representing the employer on the other hand, because of course management acts like stewards. So people have invested and they expect that you give a return to them. And so management would act in the best interest of shareholders and would want to maximize in giving a return and justify their presence also in the organization. Employees also have needs that they have come with to the organization. They would also want to maximize in terms of how much they are getting compared to what they are giving to the organization in terms of input-output ratios. So they want to also maximize on what they can get out of their input. And so that already creates some rift between them. One side trying to minimize on cost, another side in terms of how much they will spend or expenses, and another side trying to get more out of it. So so many other things. So issues of pay arise, and there's pay, and pay still has also very many components. It's not just basic pay, benefits and all that, and general working conditions, job security, and general fairness in how things are done. And so it is important that they come together and now make a common agreement that then guides how they relate with each other.
Great.
I think that's how I would, yeah.
John, do you want to add? I know you come from the same institution and you agree.
Yeah, I agree. It's just a scenario where both the representatives of the employer and the employees come together, and maybe the representatives of the employers might come up with proposals, and representatives of the employer come up with counter proposals, and you sit down and discuss, and you trade horses and agree on something.
Great. Have you had incidences where the employer is the one initiating the proposals? Patricia, you could also comment.
Hardly. In fact, they would want to avoid. If you don't come up with it, they will never.
And so you are the one to initiate.
Or when
Yes.
they're negative, when they are against the
In fact, one thing I've challenged myself, I'll be the first to set the proposal. In fact, I'm waiting for the 3 months to, and I've already made up my proposal. So I want to give, for the first time, I want to give the proposals to a union.
Good.
Yes.
Good.
Actually,
girl.
I'm the one to initiate the proposals. I want to entice them. I want to drive the direction so that I'm in control somehow. Then I'll ask them to give me a counter proposal. And they are also guys. In fact, I want to surprise them. So Patricia, that's also a challenge to ascend. We look at it from an adversarial part of it, that the union has to serve us, give us. I'm sure even some HR don't want to receive. The moment the union comes with the proposal and put it on your desk, you tell them, take it to the CEO for receiving, because you don't want even to open and see what they are demanding. It is actually the right of either party in a negotiation that can initiate. And actually, when you look at the recognition agreement and also the CBA, it will give you those provisions that either party can initiate, but hardly does the management initiate, but either party have the rights. So I look at the collective bargaining as a forum for negotiation, for the relationship between the employer or the group of employers and the group of employees, how they are going to relate. So it looks at both the financial aspects that they've talked about, the salaries, the benefits, anything that has a financial implication. And it also could look at the issues of the policy, the working conditions, the resources, how we want to relate, even in the terms of maybe pronunciation and agreeing, this is how we would want our disciplinary to look like. So you live and see they will challenge some of the things in the policy, like even you say, for us, we have even negotiated to such an extent that a disciplinary actually expires in a period of 6 months. Within 6 months, you cannot go back to that disciplinary, or a warning letter, it will have expired. From others, I know it's even 2 years, 1 year. So those are some of the things they'll say. They'll even say for any suspension to be done, it cannot be conducted by management. It has to go for the full hearing, even to a board level. So they even asked, the first step was, we want to have the management hearing, then the HR committee or disciplinary of the committee should have another hearing before an action is taken. So those are some of the things we negotiate. Issues of promotions, pending promotion, the job grades, maybe pay disparities. All these are the things that we negotiate in a CBA. So you've made my work very easy, so we will continue with that. Maybe just Patricia, do you have, you said you have CBA in KCA? Do you? Do you have a CBA?
No.
Not a recognition agreement.
No.
Okay.
No.
So in terms what it is,
and something you have said.
Yes, please.
I understand that there are some letters that expire, like warning letters.
Yeah.
I would want your position on that. Are there some kinds of letters, like warning letters, etc., that expire? After how long? And because I understand in some places they are not removed from files. What recourse does an employee have? Because in the first place, they are not even supposed to see the file until maybe somebody refers to those letters.
Warning letters, it differs from company to company and how it has been negotiated. It will be after 2 years, 1 year, 6 months, or depends on how the policy writes, because it's not in the labor laws, it's the agreement. But the best standards, 1 year, 1 year is good enough. And why we have those clauses of expiry, it is because it doesn't mean when a warning letter expires, it is expunged from the file. You have to look at the Employment Act. For what period should an employer, it is the responsibility of the employer to keep the records of all the employees for inspection anytime. So whether it expires or not, if you are given a warning letter 10 years down the line, your file, you'll only have volume 1, 2, 3. Those documents are never expunged from the file, and they can always be made reference to. However, for decision making, it does not, you remember what we were saying, the issues that are binding and can carry weight. It cannot be the reason for taking an administrative action basing on that. And why we have those expiry period, because you will find in some institution policies, they'll even say, if you are under disciplinary action, or you have such a warning letter, or you're going through, you don't qualify maybe for a salary increment, you cannot get a promotion, there are sanctions to disciplinary issues. So that is how the application of the expiry comes, that if the maybe promotion positions comes in, or there is a salary increment, or there is a bonus, and you have an active warning letter within that period, then the sanction is applicable to you and you don't benefit. That is my understanding, but it is never expunged from the file. If another disciplinary maybe case comes on, you may not make judgment based entirely on the previous one, that you can say this is a repeat offense, unless it is related. If actually the offense is related, whether it has expired to, you can say it is habitual. It can only be used to give the profile of an employee in a persuasive way, but it cannot be made for decision making. What I mean by the same line, if you are a habitual deserter of duty, 2 years, you had many cases, you even got a final warning, then you went chini ya maji for another 1 year. Then again, you start. We should be looking, and when you go for hearing, we should be looking at the current case. So if the provision is, if you desert duty for more than 7 continuous days, then summary dismissal can be done. You cannot refer that you add maybe the 4 currently, and you had a 3 2 years down the line, or 1 year down the line. If it has gone, you will only take the 7 continuous days, this particular case. And mostly when you go for hearing, let the committee concentrate on the current case. But if it's the issue of maybe fraud, 2 years down the line, you defrauded the organization 500,000 or 2,000 shillings. Then that expires. Another 1 year, you got a cash shortage if you are teller of this amount. Then the next one, there is no way you can tell the institution that don't look back, because that tells you the history, the conduct of that employee. So that is what the expiry means. There is no that standard that 6 months is whatever. It is how the union are able to negotiate. It is what is in the policy. So those are some of the things some unions will not even think about, but it's affecting the employee. But those are some of the things, even the CPA. Patricia, would you want maybe to add from your practice or what happens, or even Anne?
Yeah, I think you brought it out very well. It's more of a, institutions policy practice. What I've seen, our warning letters and all those sanctions, they last for a year. And we don't extract them from the file, but there's the good practice of just stamping expunged, so that whoever is looking at them cannot really use them again to, level charges or to make informed decision on a fresh allegation or case. But in practice, yes, they remain in the file, and they cannot be used against the staff if, the HR really knows what we normally guide. We guide them on the correspondences and maybe the past practices and, past issues and so on. But you've brought it out very well. We cannot, use, because staff, as there's correction, there is a disciplinary is supposed to advance a corrective measure. So some change and they totally change. Yeah. So you cannot judge them on, what already, and if you remind them on that, you're being unfair to them. So we are supposed to forget some of these things and value them when they change. So I agree with you. You've brought it out here. That is the practice. Yeah.
And John, if they come up when you're having those disciplinary issues, it is your responsibility. The employee may not do. It is you, with your voice as the union, to flank them out and say, even the start of the disciplinary, I will even see the union saying, I have noted in this file, we have included this in the profile of employee. We request before we proceed, or that is expunged and not considered, and that is minuted. So you are the watchdog. Yes.
One, I was asking because I have had scenarios of people who say they went for promotion interviews, and then because the letter is still in the file, it is referred to.
No, it's expired.
Yeah, it's expired, but it is referred to because it is still there. And I don't think the employer is required to tell you why you are not promoted. If you went for a promotion, you can correct me on this. Some people might be promoted, others are not promoted, but I don't think the employer is mandated to explain to you why you are not promoted. So you might have a scenario where maybe some of those things were used, but it was never said in black and white that that was the reason. That's number one. And then number two, if you go for a disciplinary, I don't think people have access to the file under management practices, so they wouldn't know what is there and what is not there.
When you go for disciplinary hearings and you're sitting before the committee, you remember in the Fair Administrative Action Act, we said you have the right to access to the information. So when you get an invitation or a notice for disciplinary hearing as the union, you have the right to write to the HR, the CEO, to request for the file, or not the entire staff file, the documents that will be relied on for the disciplinary hearing. So as the HR makes the folder for the committee members, of course, you don't carry the whole file. You will carry only the relevant, the current charges, your responses, probably if there's a summary of an investigation report, that extract of that the committee will be relying on, it's a right as a representative or an employee to be furnished with that. So as we organize, I'll see the shop steward walking into my office very early in the morning. Can I have my file? And they know it's the same as the folder. So whatever the other committees are following, they are able to follow up. So, and the committee will not rely on the confidential file for personnel file you have in the office. It is what has been filed for purpose of that disciplinary hearing. And in that file, if they come across a copy of an expired warning letter, they can say, this need not to be discussed, it need to be minuted, it need to be expunged. If you have to do a board paper, a summary of what you are dealing, the case summary, then if you take note of that, you'll see the union actually flagging it out. Let's note this, it is null and void. It should not be considered in our discussions and the discussion and decision making. So as union, you are empowered to ask for that information. You can see in the Fair Administrative Act, probably you are denied because the employer is looking at just the Employment Act, and you'll not have such discussions.
And in the example,
Yeah, John has talked of
interviews.
Promotion. Yeah.
Yes. Let me just comment before you come in, Patricia, on that. Unfortunately, we say the things that we teach in class and the grounds are different. I'll tell you from the experience of the, probably even the job interviews where we have rogue employers. Even as they are filling those panels, you know, most of these questions, mostly, it is not quantitative the way you can mark things like marks. I'll ask you, tell us about your leadership skills. And I have a score of 1 to 5, 5 being the highest, 1 being the lowest. If I'm already biased about you, John, regardless of how well you answer, I've seen incidences of some panelists scoring you what they feel like, because I'm targeting to pick Rhoda. So when Rhoda asks that question, whether she says I don't know or not, I'll score her a 5. When it comes to John, because I want to downgrade, I'll score him a 3. And I'll write lacking in leadership skills. So there are many ways, not necessarily, nobody will write because of disciplinary. Maybe there are other issues, including performance. Maybe even how they relate with the management. Are they cooperative with the supervisors? How you carry yourself? Are you reliable? You know, all those are qualitative factors that are put in place. Unless there are issues of specs. Because one thing, when you're doing the shortlisting, you must have met the minimum requirement of the job, the specs. That's the academic, the numbers of experience, all that, you have met that. But now when you go for the other interviews, there are many parameters they look, and there's many ways the rogue employers can manipulate that. So nobody will ever come and tell you, it remains a matter of, I'm suspecting maybe I was not promoted for that. But you cannot be passed by. You qualify to be given that opportunity. So if actually what I normally see the employees or even the union, if the specs of the job are this, and I made an application and I feel I met all the qualifications, you can even write to ask. I've seen employees writing to ask, I want to know the criteria that was used for shortlisting that made me not be shortlisted because I feel I should. You owe them an explanation. You'll tell them you have CPAK, but because you are not a member of ISPAC, that is one of the criteria that dropped you, and they will understand. Or you are recently promoted, you have not served in the previous position for a period of 3 years for that. All you lacked. And that is why as HR, when you're doing recruitment, ensure you have the whole long list. Ensure you have documented criteria for a short list, so that if an employee always come back to find out, you have a reason for it, not being shortlisted. However, for those who qualify to the interview panel, then those other factors come into play, and it becomes very hard. And that's why you say the culture of the organization, the environment, and the vested interests also are part of the factors that come into the play, John. But no employer would expressly say it because you had a warning letter that had expired. Patricia, you can hear your comments.
You have actually picked up. John had the concerns. Why a staff, feels they qualified, but they were not promoted, and there is no feedback. I think it's more on the communication there. Yes, when you brought out the fresh recruitment, there is the long list, and you see recruitment can be audited. So documentation is paramount, such that whoever comes to that can still really confirm that the candidate taken was the most suitable and qualified for the position. You see, there can only be one winner. And unless there is obvious politics and all that, which really, as you rightfully call them, rogue employers. But my experience is that when an advert goes out and the profile of the job, the person is properly outlined there. And then the recruitment process is also, we have a tool for the interview that can be verified and has the right weightings. People are for self-preservation, they feel they are better than the other, but it's never the case, because interviews are conducted with a panel of interviewers, and normally they are qualified people, they're people who have been vetted and can carry that exercise. So it could be just somebody's own feeling. Some people feel they're better than others, but the panel has the prerogative to only come out with one candidate or two if the positions, the slots are more than one. But the issue John is saying is where now feedback, even for whatever case, you still need to give feedback to those who participated in the interview. Let them know somebody else was found more suitable. They know normally the way we write it, but in future they can still be considered, and thank them for even expressing interest in serving in in that company and so on. So that feedback is important. However, sometimes you have too many applicants, and it becomes difficult even to respond. So the other thing is now to embrace technology. Sometimes you just have this one standard response that you can give to even the other support staff in the HR to give feedback to them. That one I've heard that it's very frustrating for a person who expresses interest in a job and there's no feedback. Yes, and that's where it comes for promotion, where it comes for promotion, it's normally very it's a very emotional affair, especially when you've been there and you've been working. So, and you probably believe if so and so is in that panel, then I'm not getting it. So those ones, that can be a person can feel demoralized or not fairly served and so on. So feedback and fairness, and a tool that can be verified and can pass the audit, for even an external audit exercise kind of thing.
I can't agree more. So thank you for that, John. Hope we have answered you.
Yes, we have.
Great. So now we talked about the benefits we normally negotiate. That's the terms and conditions of employment. I expounded on that. Dues paying employees. You remember when we were saying the due paying employees and members, and also the free riders. The free riders is where now we get them through the agency fees. I think Anne had expounded on that. Then the government role is normally mediatory or neutral, or maybe in case in the CBA, the two parties, which is the employer and the employees, the representative, if now they reach a stalemate and are not able to agree, then the government becomes a mediator. You can see now the employees have their union, and they have the COTU, which is the union representative. Then the employer has the management team. They have the FKE that they can agree with, or both parties can agree. Let's have like FKE, they would even share those negotiations so that you leave the government out for mediation. We proceed. Then collective bargaining, we are saying it's applicable in all the countries, and it's grounded on the ILO Convention number 98 of 1948, which is right to organize and also collective bargaining. And this was ratified in January 1964 by Kenya. Then it was also domesticated through the constitution. Now, when I say the domestication of the ILO, you understand the labor laws and the industrial relations code of 1984. Then in terms of the constitution, I think we have explained Article 41 severally. I'll not read them. And again, we are saying the Labor Relations Act also has defined the boundaries for trade union organization, the recruitment, who can join which one. If you look at them, it will have all those parameters. And it also has brought about the issues of fundamental rights and freedom of workers. Then it involves unions and also the employers. It presents the major labor offensive, and had said that during the CBA, there is a labor offensive because one want to get to minimize on the cost and want to give as little as possible so that they maximize on the profit, and also look at the economic parameters. Then the union, they're looking for the welfare and what is it It's actually what is in it for everybody. Then the guiding principle is normally the CPA and the wage determinants. The CPA is consumer price index, the productivity of the organization. So that's when you look at the performance and how we are performing as an employee or as an employer. Then the firms and the economic performance, you normally look at the inflation rate and also the ability and the sustainability to pay, because you have had cases that when the union has pushed too much, the organizations have no ability to pay and they end up collapsing. A classical case, in fact, which I was telling Kufau, because they are also the ones who drove the CBA negotiations for Tuskies. And one thing I told them, hope you will not push this institution too much to pay, because you remember it was all over the newspapers that the Tusky employees are being paid higher than the bank tellers. And what happened? The sustainability and the ability to pay was not there, and they ended up even losing their job. Then the wage guidelines, the way it has progressed over the years, it has grown. Then the CBA contains staggered long-term contracts, conditions of employment, and also the fringe benefits, because you might go and negotiate CBAs for 2 years, 4 years, or the many years you have, and then the implementation is normally phased. Then the CBA duration, mostly it is 2 years, or maybe you add another 1 year to 3, or the 4 years like what we have in the SRC. Then we have the collective bargaining systems. What are the types of the system we have in the collective bargaining? And someone was asking, you can have what we call the enterprise or the organization-based collective bargaining, where the union negotiate with a particular organization. I'm one particular organization on my own. I negotiate with the union that we have the recognition agreement, and we agree unless any union has recruited more than critical mass of 50+1, it is only then that they qualify to sign a recognition agreement with the employer. And once they sign the recognition agreement, that gives them the right to enter into collective bargaining. So apart from the organization, union, negotiation kind of a system, we also have the sector or industry-wide collective bargaining, where we have CBAs for the industries. We have some examples that we'll have is the DW, the Dock Workers Union, and the Kenya Ports Authority or Kenya Ferry Services, which is a collective group of employers, and the union has many people, that is industry-based. Then we also have the mixed system, where you can have the enterprise and the industry, like the way I've explained, or you can have groupings of enterprises according to their size or maybe their tires, and also groups of probably the union representatives. And I'll give an example of the KUPAU. It's called what? The Kenya Planters and Agricultural Workers Union versus the Unilever Tea Limited. So that is a union that has different members in the plantation and agricultural sector, who goes into negotiation with one firm, which is the Unilever tea industry. You can still have that umbrella of the union, the Kenya Planters and Agricultural Workers Union, versus the KTGAs. The KTGAs is the Kenya Tea Growers Association. So it is an association of many tea and coffee growers that comes together, and they negotiate as a block. They negotiate as one block. And maybe maybe some of the Kenya Tea Growers Association, some of the members, if you look at into the union, they have the James Findlay Kenya Limited, all the employees are there. They have the Karirana Estate, they have the Nandi Tea Estates, they have Kaisugu, the Williamson, all those they come together to form what we call the Kenya Tea Growers Association, and they negotiate as a block. So whatever comes out of that, they have one common CBA that is implemented. You can also look at, you go to a particular industry entire, so that you have the minor and also the major. If you look at like what happened to beef, that's the banking industry, you'll find like the small tier 3 banks will have a CBA that has different salaries and benefits, considering to tier 1 banks, the Standard Chartered, the Barclays, in that category. So those are the various systems we have in terms of the CBA negotiations. Then the challenges. What are some of the challenges of collective bargaining? I think at the beginning, Anne alluded to many of them. It is the working out attitude. So when you go to the CBA, you are all sitting at the opposite side of the table. And the question is that what you are asking, even for the union, is what is it in for us? When are we going to close this? When are we going to agree? How much are we giving us? What does that mean? This is the kind of adversarial discussions that are there. So, and we have different other factors, whether you're in the private or in the government, whether they are youth, women, people with disability consideration, and also the aging membership. You'll find like in the union, maybe Anne will agree with us, the older generations, that's the X generation and maybe the baby boomers, they really believed in this union movement. It was a do or die activity, and it was very easy for the union representative to recruit. But the young people, the generations that are coming, the millennials and the Z generation, are they really proactive that any moment they join in, they come to an institution, they really want to join? There is no that commitment, because even as they join and they come to your institution, they are looking at it, I'm not here to stay for long, I'm here for 1 year or 2 years. Why do I join you? They feel it's a lifetime. It's just like the circles. Anybody who could go the last, where is this circle you want to go save and borrow? But nowadays, even the issues of the pension, the employees want to just work for a few years, get their gratuity, buy their Subaru car, buy maybe the move from one estate to another. They don't see that long time commitment that maybe the other generations in our time could really feel. So the other challenges we normally have is the drafting of terms of the demands and the offer. We have confirmed very few management people initiate the proposals. They always have the union, probably, who also have the challenges of drafting the proposals and the demands, and also the offer. When all that is done, how is it communicated so that whatever demands and the offers we are giving, when we read them and we interpret them, they mean the same thing to us? Then deciding on the limit on the consensus, you are torn between what if we give this in the financial and financials. By the time you arrive at the limits of consensus, because probably when Anne was coming, they were asking for 300% salary increment. Then when Dora is coming, he said, I can't give anything. Because of COVID, because of Corona, the economic hard times, the performance there, you can imagine by the time you come to the limit of a consensus that we are dealing with 1 digit from a triple digit. By the time you come to the second digit and come up maybe probably to give a 5% at the end of the day, it is very so the difficult problem is when we have very high demands and very modest offers. Like Rhoda is coming with 0%, you're demanding 300% because you feel your workers have really worked hard. Then as a continuation, I have classified the dangers into 2. First, if much is demanded at the onset, so that the individual claims has to be withdrawn or whittled down to make any agreement possible. Then if final agreement falls considerably short of the members' expectations, then there are dangers to that. And some of those will be, the members will be either be disappointed, the members may reject the outcome of the negotiations. We have had where union have gone into the negotiations and they have come up with the offers and the proposal, and when they go back to the members, they face a lot of hostility, and actually their leadership is also at threat. They may lead to strike. So the issues of the strike management should be able to be one of the key concerns for both the union and also the management, so that we make all this efficient and maybe beneficial for everyone. May lead to membership withdrawals, because they feel whatever you went and negotiated for us, probably you've been compromised by management, it is not serving us as the members. Then the loss of confidence on the union officials. Then the second danger is if unreasonable and negligible offers are made, or if the hardball tricks are used. Ile, everybody anakaa ngumu. I'm not moving from 300, I'm not moving. So we can adjourn the meeting. We keep on taking the meeting. You know the delaying tactics that we normally use in the CBA? May I? Union normally are very good at this. Mother, may we go out for a short period and consult? They might walk out of in one single meeting 4 times to go and consult. They ask for 5 minutes, they come back, then you sit for another 10 minutes, they ask for another. So negotiations are the meetings you can sit from 8 to 5 and with a lot of breaks. And you say, can we, if we are not able, we are not coming with the spirit of negotiation, can we maybe shelf this and come? And you know, time is also running. Then the union may also decide to withdraw from the negotiation because they can see there is no goodwill from the management. All a stalemate or loss of productivity and cash flow. By the time you're coming from those negotiation discussions on the tables, whether you do them offline, which is or offsite, which is the most recommended, by the time they take those breaks, they are connecting with their members. They can tell how Rhoda is dressed. They can tell the mood of that meeting. They keep in tab, especially with now the technological advancements, the members know. And you can imagine at that time when we have a stalemate, there is loss of productivity. There is hardly anything that goes on in the organization. And that also affects the bottom lines and the cash flow. Then alternative industrial actions that they could be go slow, lockout and strikes and what have you. So what are some of the key issues when it comes to collective bargaining? We are saying collective bargaining requires rationality. Both the employer and the employee should be very cognizant of the economic hard times and how the performance of the organization is. They should be able to look at the financial statements. They should be able to look at the sustainability, what is possible, what is not. And the employer should look at where is the employee coming from. And also the union should look at what are the challenges that the management is facing that we can work together collectively to resolve so that we are able to have this organization running and profitable for our job security. Information sharing is very critical. This is the time now the union will ask, we want the PC for this period. We want a copy of the financials. We want to see the budgets. We want to do this and this. All those things, they look at them. So that free sharing of information and even the challenges where you can sit with the union and say, if we continue with this wage bill, if we continue, then there are risks to us. So that kind of engagement is really very useful. Trust and confidence building is very paramount. If you're able to negotiate in an environment of trust and confidence in each other, that nothing is being hidden from the other, then it becomes much easier. Then collective bargaining should be seen as a win-win game. And positive labor management partnership is very vital, which is being promoted by the ILO, and the knowledge and measurements of compensation parameters are very key to both parties. And that is you can see the work culture and the attitude. Does anybody feel this is how the workplace looks like? Look at the wheels of that cart. Look at the way it's loaded. Look at the way the first guy is really struggling to move square wheels. Yeah, the management can make them a bit round. Look at the guy who is pushing. The sweat and the frustration. That is normally the work culture and the attitudes that we have. So that is all we'll cover today about the CBA. Let's see a comments and Q&A before we go to the last session. I can see we only have 20 minutes to 11. Any comments? Green light to proceed.
Rhoda, you can proceed. You can proceed, Rhoda.
Great. I know the likes of Anne and John, this is their comfort zone, and they know how much we can talk about. Maybe in a deeper forum, we could look at the whole procedures. This is a topic you can train the whole day if time have. There are a lot of things that you can discuss. So I will talk to Dan so that we could even organize just for a training for CBA negotiation for 2 days, and we do it thoroughly. Great. Then we go to the last topic, which is ILO core conventions. And also the case laws that we want to look. Yes, so the last session, we are going to look at the ILO convention. We will not go into depth because yesterday, I think we covered and I gave you the example. So it's just a repetition of the same majority unless something that comes up. But maybe just to understand, when we say ILO, who is ILO? What do they do? What is their intention? Why do we have to be members of ILO? How do you become? How do we ratify? How do we sign? What are the requirements? What are the demands of that country? That's just what I want to cover. So in terms of ILO, we say ILO is the only tripartite UN agency since 1919, and it brings together governments of member states employers, and workers. So the member states, they have about 187 member states. I don't know if more has joined. And the purpose is to set labor standards, develop policies, and devise programs for promoting decent work for all men and women. That is basically who ILO is. So they have brought an UN or an international forum where the employers, the employees, and the government sit on one table in a conference to come up with a labor standard that favors everybody. And everybody has an equal voice on that table. You don't come with your government tags and I come with my employer and this. So all the policies are looked at the same lenses under a level ground. So the unique structure of ILO, it gives equal voice to workers, employers, and government to ensure that the views of the social partners are closely reflected in labor standards and in shaping policies and programs. And the main aim of ILO is to promote the rights of work, encourage decent employment opportunities, enhance social protection, and strengthen dialogue on work-related issues with the three tripartite. And this is highly, and it is actually initiated and supported by UN state members. So it promotes social justice and internationally recognized human and labor rights by doing these two things. Their role is setting and supervising the applications of the conventions and recommendations, that's international labor standards, for the people who, for the ratified and they're signed by various state bodies. Then promoting decent work. We talked about decent work. So now the term decent work, I think now you can relate how it came from the UN and the ISO standard and what it means. It's not just a layman's basic word in HR when you talk about the decent work. That is work in dignity, safety, freedom, and giving technical support to governments, trade unions, and also the employer. So they also give their technical support and sponsorship and strategic partnership to any of the three. So they are not union biased, they are not government biased, they are not employer. They give their technical and support in the same measure as one block. So in terms of the ILO conventions, so what are ILO conventions? When we say we have this convention, what do they mean? And we say ILO conventions are labor standards drawn up with a view of them becoming part of the national law. Once the conventions have been adopted by the ILO conference, which happens annually, it is then up to member states to ratify them. So the first step, it is them to be adopted by the ILO states. Once they are adopted in the conference, which is now like a conference, it's a conference, the way you can do something and propose, and then it is proposed, seconded, and then it is adopted. Then members have to ratify, the individual member states now normally ratify that convention. And it is a requirement that a particular adopted convention must be ratified by a certain number of countries, which they'll give, maybe half of them, before it becomes into, or maybe 50 plus 1 into force. So if they don't meet the number of people ratifying that, it cannot be applicable, or it doesn't become, it does not come into force that it can be implemented. Then we say ratification takes time because it's voluntary. It is not compulsory that once it's adopted, it has to be ratified. It is voluntary, and different states members will come at different time. Once it's ratified, then it binds the countries concerned to implement the convention in national laws in their country and also in their practice. So they're expected to come and domesticate them the way we are doing them in the constitution and also in our labor laws. So again, we gave, I think, examples of the 10. I think all of them, we gave examples, the 10 of them, so I may not go to them. So there's convention number 87. So you look at the numbering of the convention, they run numerically and also the year. So if you have a lower number, then you can see that's an earlier convention. Convention number 18, freedom of association and right of collective bargaining, that was in 1948. Then later, the convention number 98, right to organize and collective bargaining, 1949. You can see the way they are moving in consequence. Then convention number 29, you know, it's an earlier one. So this was done in the 1930 on forced labor. 105, on the abolished of forced labor, 1957. Then 138 on minimum age of entry into employment, which was done in 1973. And I may not read one by one. There is one on the worst form of child labor, 1998, up to the one for Convention 120, and on Commerce and Office Convention of 1964. So you can, if you Google and say the ILO conventions ratified in Kenya, then you can be able to get all that list, and you'll be able to actually read about them to just understand the whole of that. It should also be your target one time before you retire in HR to attend the Geneva conference for ILO, because now you understand what they do and the kind of, so that you can interact with different people. I know FKE does. I know even COTU, and also the government, the Ministry of Labor. Those are some of the things, and even the big organizations, they'll sponsor their people to go there. Reasons why the core. So if you have the opportunities for those international exposures, one time try to apply for Geneva so that you can be sponsored, because you are the HR practitioner, and then you can see the basis where you can justify why you need to attend that forum. Then reasons why the core labor standards are needed. There are 5 main reasons, but I know there are more than that. Equality and social justice, we talked about that. Ending the race to the bottom. The race to the bottom means this cutthroat competition, and what Anne was saying, everybody is pulling to there, that the employer is trying to spend the minimum cost, compromise on the standards of the workers, not ensure there is job security or safety of the employee, or the employee also want to actually almost kill the organization by making unrealistic demands. So it focuses on bringing the 3 stakeholders together so that they are able to end that race to the bottom. And we come to a middle class, all of us. Decency and dignity, alienating of poverty. We have looked at it even in the Agenda 2020 and also the MTPs. Then creating space for workers to organize in terms of the formation of the union and also the collective bargaining. What are the requirements by the trade unions? So when we look at these standards, what are our union counterparts looking for when they are looking at these standards? For them, the focus is they want more effective implementation of these standards. And you can see now the agitation of COTU and driving so that we ratify these ILO conventions and we domesticate them, and we come to review of the labor standards and also the labor laws. Greater enforcement, that's what they are looking for. A practical commitment to social dialogue, that's what they're looking for. And agitation, organization, and also action to see that these things are taken in place. That's the end of ILO conventions. Now we can demystify what is ILO, what are conventions, what happens in the ILO conferences. Now we go to the most awaited topic, which is the case law. Case law, as I said, the case that we know we have, I don't know if you, I will share with you, but if you have your phones and you can Google, you'll also do that so that you can understand, but I'll also try to project so that you can see how it runs. But ensure after this, that will be your homework. Go look at it, read it word to word. You'll be able to understand the structure. So what is case laws? We had explained this yesterday. We say the collection of past legal decisions written by courts and similar tribunals in the course of deciding cases, in which the law was analyzed using these cases to resolve ambiguities for deciding current cases. These past decisions are called case laws or judicial precedents, and that is what we call the case law. So we have only 2 cases and a conclusion. So the first case is a judgment. It is a Supreme Court judgment, and it was a petition of number 4. If you Google petition number 4 of 2019, if you Google that, you can download in PDF and you have it for your future reference. So petition number 4 of 2019. And this is a case between the Law Society of Kenya as the first petitioner. That's how they're normally worded. The first petitioner is the person who petitioned or who appealed for the decision of the Court of Appeal. And the first respondent was the government. And when you sue a government in labor matters, who is the legal counsel for the government is the Attorney General as the first respondent. And then we'll see along, they also admitted because it was a matter of challenging the constitutionality of some of the clauses in the WIBA, they admitted Kotu as an interested party to the case. Because you see in the coming up of this labor law, Kotu worked very closely with the government to ensure, and they are the people who have pulled these things from the ISO convention. What was the thinking? What was the discussion? What was the interest? What was the name? What was the aim? So Kotu was drawn into this case. So allow me to just upload that case and just give ourselves some highlight. So that we just see the structure. That is petition number 4 of 2019. You can see it's a 16-page document. You can see it on your end. Kindly confirm you can see it. Anne, are you able to see? John?
Yeah, I can see the PDF.
Yeah, yes, it's there. Yeah.
Okay, so I will just run through this case. Maybe just, I've said who are the parties. So the first page will have just the details of what the case is about, is being presented before which court, which is now the Supreme Court. You'll see the parties to the case. So you normally start with the petitioner, then the respondents are listed there. Then you'll have the first, the second, the third. You can have as many respondents as you can. And then it just have a summary. What is it? Is it a ruling? Is it a judgment? So we can see it before the Supreme Court, and you can see it's a judgment. The judgment is the final decisions that has been made. It's different from a ruling. So when you're looking at the case law, mostly, I really want to prefer to look at the judgment, because it talks with finality and a decision. The final decision has already been made. So again, what is in bracket is telling you it's an appeal from the entire judgment and order of the Court of Appeal sitting in Nairobi, and those are the judges who had sat in that case, and they delivered that judgment in November 2017, allowing a civil appeal case, which is there, which you could look for it. So they're looking for judicial review of that, and maybe to quash the decision of the Court of Appeal. Because what had happened, the High Court had actually made a decision and actually agreed with the petitioner, that is the Law Society of Kenya, that some of the clauses that are in the WIBA are actually offending the Constitution, and they should be regarded as null and void. So that is the ruling that was done at the High Court level. Dissatisfied with that decision, the Attorney General and Kotu filed a case against the Law Society of Kenya at the Court of Appeal, seeking to appeal the decision of the High Court, rendering those clauses unconstitutional or offending the Constitution. So what happened? Actually, the Court of Appeal quashed the decision of the High Court and determined, after much analysis, that actually what has been considered as unconstitutional by the High Court are not unconstitutional. So they went to the historical development of all this, and they could see the way a task force was formed and what. Then they could see the ILO conventions. They could analyze various papers and see where was the initiators of the drafters of this statute, where were they coming from. So after that, they actually came and said the decision, the High Court had erred in rendering those of the clauses unconstitutional. So they went, so now this case now turned against the Law Society of Kenya. Then the Law Society of Kenya now dissatisfied with that question of the High Court's decision by the Court of Appeal. They went to the highest next appeal level because it is a case that is affecting all the workers because it's WIBA. These are labor relations, the FKE and the COTU. So they went to the, and it was a case of with public interest, and it was offending, or they needed the interpretation of the Constitution. And looking at when the WIBA was actually approved, it is a 2017. It is 207. So this is a 207 document. So the reference they could make reference to was the former Constitution before the Constitution you have for 2020. So there's a lot of reference to the former Constitution, and also relating how does it now, can it be interpretation in the transition Constitution of 2020. So that is the kind of analysis that has gone into this case. So at the Supreme Court, as you'll see at the order, actually, they upheld the decision of the Court of Appeal. And you'll see at the end, as this was happening at the Supreme Court, another case that is related was also filed in Mombasa before Justice Ogolla, who actually went and hurriedly made a decision knowing there was a pending case. And you can see the backlash that is coming from the court, the Supreme Court, actually condemning the judge for having made a hasty decision on a case, knowing there was a case that was pending in the highest court in the land. And actually they could even tell him and lecture him the way he should recognize the court structures, and he should have held on his horses. So what is this petition all about? So if you look at the structure of a judgment, you'll have the introduction. So the introduction, are we together? We are together. So the introduction will tell you what this case is about and what is being challenged. So this kind of case, it is challenging the decision of Court of Appeal that had those three judges. And the Court of Appeal, in its judgment, had reversed the order of the High Court that had declared the various sections.
This one hawatamaliza.
Anne, you're asking, is it Anne or Patricia? We have some background noise.
It's Anne. She needs to mute. She needs
Anne,
to
kindly mute.
Anne.
Good. So we can proceed. So the introduction is just explaining what I had explained earlier. And now for you as a HR practitioner, I'd want you to read and pick the High Court had declared those sections in the WIBA. We have section 4, section 7, subsection 1 and 2. There was section 10 that was also contentious and 4, 16, 21 and 1, 23 and 1. I want you to note all those sections that were actually being contentious, and they were challenging that Court of Appeal decision that declared them. So the challenging the decision of the Court of Appeal that declared that those sections that have been cited of the Work Injuries Act of 2007 null and void. And because according to them, they feel they contravene certain sections of the former Constitution. Then after the introduction, so you know what the matter is all about, and you can see it is relating to what we were discussing. They'll give the background of the case, how the Attorney General appointed a task force to come up to review all the labor policies, and one of that act was the WIBA. So it gives you the background of how was it reviewed and how did it come into force. Then it also gives the background of what did the High Court do. So in that, you can see what happened here. The High Court, what the activities that happened in the High Court, and they are saying the learned judge of the High Court, which is J.B. Ojwang, as he was then, considered the evidence on record and submission of both parties, and his judgment declared as being inconsistent with the provisions of the retired Constitution. They have given those sections. The respondents were further condemned to pay costs for the petition. Then they can show you how the case proceeded to the Court of Appeal. So being aggrieved by the decisions of the High Court, the Attorney General filed a civil case that arguing that the landed judge had erred in his decision by declaring the 9 sections of the WIBA inconsistent with the Constitution. Then it can also tell you what was the finding of the appellate court. So all what I've highlighted, you can look at what did they look, what did they analyze, where were the errors, what are the areas that they agreed on. Of course, there are some clauses they agreed on, there are those that they didn't agree on. Then, aggrieved by the decision of the Court of Appeal, now the petitioner, who is the LSK, is seeking the following relief. So what they are seeking, what are their prayers when they go to Court of Appeal? Their prayer is this: an entire order of the Court of Appeal decision to be set aside or to be quashed and substituted with a fresh judgment. And also the issue of, they want now the High Court decisions that had been earlier made affirmed, and also the issue of the cost. So that is what their prayers are. Of course, now that is split into different sections. They'll talk about section 16, section 23, section 25, 52, one by one. That is how it is flowing. Once we have all that background, now we have the submissions. The way now it is organized, you have the submission of the petitioner. Always you look at the person who is the complainant or the petitioner. What are their submissions? And they give written submissions with ground before we come to the oral submission when we come to the hearing. After now we have the submission, their argument, the burden of proof, it's actually on the petitioner. It is the person who has filed the court of petitioning that has to give all the supportive document and the evidence and the justification why they feel that one. So they take the lead to this. Then we'll also have the submission of the first respondent, the second respondent. So we have all those submissions given together. And what I have highlighted, when you talk about the case law, in giving your submissions and your justification, they must be supported by statute, constitutional provisions, and other case laws. So you cite, our argument is being sought and supported. So you can see here, like on this page, they are saying the petitioner relied on a decision on a civil case appeal. So you will rely on such cases that the court had pronounced themselves. And everything they pick, there must be a case law to support, either to persuade or to actually influence the decision of the Supreme Court or the court you are appearing before. So that is all what is happening. After the petitioner, now we have the submission of the first respondents and also the second respondents, where court will come and say the ILO conventions, the fair labor practices, according Kenya has ratified, they have signed, we needed now to be domesticate, this was just. So they give the historical background and where they're coming from. After all that is done, then the judge will have to actually listen to all that and classify what are the issues of determination. Issues of determinations you'll find in every court, and they are about less than 5. They look at all that analysis and say, what is the role of the court for us to determine? So you see in this case, now the issues of determinations are only 2. It's whether section, all those sections that have been isolated, that had disagreement, that were not agreed by the High Court and the Court of Appeal, it is to determine whether those clauses of WIBA are inconsistent with the former or the retired constitution and also the current constitution of 2010, because it's the Supreme Court of the land. Then they were also to look at what orders do they give. You remember the judicial orders we give? Is it to quash the decision? Is it mandamus? And who will bear the cost? Looking at it is a public case and a public interest case. And then after that, they have determined what are the issues of determination. They will analyze every clause by every clause and the submission. So all what I've highlighted is the analysis of the court. So they have given, and also in their analysis, they'll also give the rationale and the approach. The approach, we have different interpretation of the law and the constitution. So actually it is the responsibility of the court or that is sitting to give the rationale and the approach. And they'll say their argument is based on the supremacy case, or they will cite both international and local and international cases. So you can see in their argument, you can see the cases they are relying on. and they will come. And they say the object of the court interpreting the legislation is to give effect as far as the language permits to the intention of the legislators. What were the people who are making the law making? And they'll give their case laws as well. Page 9 is where I want us to concentrate again. This is just argument. I may not be able to read by it, but page 8 and 9, I looked at it to be very eye-opener. And if you look at that, they give the background of why WIBA. And they could see it was seeking to provide insurance to employees and to related matter. It further incorporated the 1998 International, ILO Declarations and Fundamental Principles and Rights of Work, ensuring that the human values and vital and social and economic developments were being upheld. You see where they are quoting now ISO. They are looking at what was the drafters of this legislature trying to cure. So all that background is given and they are able to do the analysis. So that's still the analysis that the court go through. And they'll also look at the previous legislations that was there, like the workers' compensation, and look at what was the mischief that this new legislation was trying to cure. So like that statement, paragraph number 50, it is talking about workmen injuries suffered in the course of employment. It was what was covered in the previous legislation. However, now WIBA is trying to provide compensation to employees for work-related injuries, and they also added the diseases contracted in the course of employment and connected purposes. It also goes further to make it compulsory for employers to provide insurance covers, so they can see the cure, what they were trying, and the mischief that this new legislation was trying to actually address, and they take that into consideration when they are giving. So they also look at the purpose, the purposive interpretation of the law. What was the purpose? What is the intention? Is it for the general good of the workforce, for the welfare, though, apart from what is written in law? So those are the things that they are looking for. And they are then page 9. So after they did all that, I want us to look at maybe just the first section. This is what is being interpreted in all the section. So the issue of section 16, what is the contention all about? That, and then, so they'll give those clauses as they read, that no action lies with the employer, the employee, or the dependents in case of an accident and the recovery. And they are saying, what is the contention about that clause? So they will cite the way the clause is, and all of them, they are cited there. And they'll come to paragraph 57 and say, the bone of contention by the petitioner with regard to that particular section of 16, it is that it is extinguishing employees' right to file an action for damages in respect to any occupational accident or diseases resulting from disablement or death of such employees against his employer. So they're saying that's the contention is that this provision is actually infringing on the employee's right to property under Article that and that of the Constitution, and it is restricting the enjoyment of the right to access to justice and also fair hearing that has been provided in the Constitution. And then the Attorney General, on the other hand, argued that the section is not unconstitutional and it is just a mere ouster of the clause, which is permissible under various laws. It is also the petitioner contention that the effect of that section 23, it confers the judicial authority. You can see WIBA has given a lot of powers of determining how much compensation to DOSH. And according to this petitioner, this should be left to the courts to determine and not the DOSH. So those are some of the contended issues that if you read that case, you'll be able to understand. So those are just some of the examples of the contention. And you can see they have dissected each and every section and the clause of that. So paragraph, what you see numbered 50, 57, they are paragraph, and that's how normally a judgment, it is numbered from number 1 to the last paragraph, and you'll be able to follow in that order. After they do all that analysis, they are going to give a conclusion. And this is actually after every issue. You see, the first one is the constitutionality. They will give, after they do that analysis, they have come up with a closing remark or a consideration, saying, following all that analysis that they have done, it is apparent that in considering the nature and the extent of the limitation placed under that section 16 of the Act, it becomes clear that it does not permanently limit the right to access to court by a aggrieved party. It is also in the initial point to call for decision in workers' compensation. When read in whole with section 23 and 54 of the 52 of the Act, therefore, a party is not left without access to justice. There is still a window that you can access the justice, nor does employees or employers have to resort to self-help mechanism. What the section does is that it allows the use of alternative dispute resolution mechanism to be invoked before one can approach the court. That is the analysis and the conclusion of this Supreme Court on that section 16 that we had read. Then they are saying, we must, in concluding this issue, this particular issue of section 16, and also acknowledge that this is a system that has been operational without complaint from employees through their union, as diverged in the court by COTU. COTU say they have not had any union complaints about it for over a decade since the implementation. We therefore find no reason to interfere with an already efficient system. It is our finding, therefore, that neither section 16, 23, nor 52, 1 of the WIBA, we've just done one analysis of that, can be said to be consistent with the former constitution or the constitution of 2010. That is the kind of the analysis. Then they will go to their second issue, section 21 of the WIBA in inconsistency. They'll do a similar analysis. And before they go to the next issue, they will also come up with their own conclusion, which you can read on your own. I said this is just a stimulating discussion. Then they'll go to the other one, whether that section is inconsistent. A similar analysis, a similar conclusion is arrived at. You see, they are continuing what I've highlighted. You can still go highlighting because that is the structure on the judgment. Then also on the issue of the relief, actually, who will bear the cost, whether it's the petitioner or it's shared, but this cost was not allocated because it's for the public good, and there was, so they said, they dismissed the case without cost. Then at the end of the case, there is the part of conclusion. I said we have introduction, background, the submissions of all the parties, verbal, oral, all those. The issues of determination, you crystal them into 1, 2, 3, 4, 5 as per the court findings. Then the analysis is what carries 3/4 of the case. And then the conclusion. So what was the conclusion of all these cases? And I want us to read that the present appeal was straightforward and we have settled the questions placed before us for determination. However, before we conclude, we must take note of the matter that was brought to our attention at the hearing of this appeal. While this matter was before us waiting for determination, Eric Ogola, who is a judge in Mombasa, on 10th of June 2019, in the High Court of Kenya at Mombasa, rendered a decision in the case of Juma, Nyamawi, Dungo, and 5 others versus the Attorney General. So the first one, you start with the complainant, then the other person. At Mombasa Law Society, who are an interested party into the case. Constitutional petition number 198, you can look for it. And I think that's why we were saying some clauses were rendered unconstitutional. And you can always get from the e-Kenya law reports. Broadly, some of the issues of determination in that case included whether WIBA was unconstitutional in light of the Constitution 2010. So they are saying, we were greatly dismayed that the landed judge did not take the judicial notice of the pendency of this appeal, although he was aware of it. As a matter of fact, he stated so in his judgment that an appeal had been preferred to us against the decision of the Court of Appeal at the Apex Court on matters whose determination may well have been binding on him. The landed judge ought to have held his horses and acknowledge the hierarchy of the courts and wait for this court to pronounce itself before rendering himself. If at all, as we perceive it, his judgment has created unnecessary confusion in the application of WIBA and cannot be allowed to stand as it may or is, also be contrary to this judgment. The findings and the orders expressed in that judgment must therefore be read in context of the decision of the Court of Appeal and our findings and orders of this appeal. This is all to say that on that matter. Then they give the final orders. So the final orders that they give, you remember the judicial review orders that we have? So the order they gave on this petition number 4, appeal number 4 of 2019, they say the petition of appeal number 4 of 2019, dated 1st February 2019, is hereby dismissed, meaning the decision of the Court of Appeal that say the clauses are not unconstitutional was upheld. And for avoidance of doubt, the determination in civil appeal number this, that done by Waki, Mkadia, and Ouko, is hereby withheld. And that brings the case of the end of this case. So I hope you have understand the structure and how you interact with a judgment or case laws. That is how you do it. These are documents that are in public domain. You just Google once you know the case, the case law, and download it and put them. I have a folder called employment case laws. And especially now, if you're binding like the WIBA, actually this is a law in terms of the WIBA. And this is how now you, for the HR, I would print it and even put it in a file. Because that's, unless that, and it has been determined by the highest court in the land, then you file it and that is law. Over and above, what is it in the WIBA? Also download the Court of Appeal, which has been upheld, because maybe there are some clauses they agreed with the court, with the High Court, and that also forms part of the law. So that's bringing me to the end of that dissection of that case. Allow me to go to the next. It is already 11. This one is, the other one is a very small one. It's just a ruling of 5 pages, and I'll not read to it, so that we just understand that is what is happened. So that is a full judgment at the highest land, which is very good for me. It's just to intrigue and to guide you on how to analyze and how to access this. So this is a case of Kenya Electrical and Allied Workers versus an employer called Watisla East Africa Limited. And again, if you look at page 1, it tells you this is a case between the Employment and Labor Relations Court. The other one was Supreme Court. It tells you the cause law. So when you Google this cause law, you'll be able to download. Then it is telling you it is before which judge. Then the parties, it starts with the claimant versus the respondent. So when it is it's an appeal case, you have the petitioner or the petitioner versus the respondents. When it is a high court case, mostly you have the claimant, the person who is laying the claim, and also the respondents. Then this is not a judgment, it is a ruling. A ruling is where you approach court to make a decision or to make a judicial order for something to be done, as we have looked at that. So this is an application. It also gives you what it is, and what are the prayers. The application before the court is the amended notice of application, because they had done an earlier application and then amended it. And what we are doing, that the Honorable Court do issue the prayers of this ruling to the court when this union went. It is, they prayed that the Honorable Court do issue orders directing the respondents, who is the employer, to commence deduction and remittance of union dues from their employees who have already acknowledged membership with the claimant. Then the court to issue orders restraining the respondent, its servants, its employees and agents from victimizing, intimidating, coercing, harassing, terminating, dismissing, and displaying on account of their union membership of the unionizable employees and the claimant. They also sought orders to the court to issue orders directing the respondents to sign the recognition agreement, because according to them, they had already gotten the critical mass of 50+1 as per the Labor Relations Act. Then that the cost of the application is provided in favor of the claimant. That means the cost is pushed to the person who is accused. So the issues that were brought, you'll just read. It's a 5-page document. So the issue is that the respondent had refused to sign a recognition agreement, which was in violation of the freedom of association and the right to fair labor practices. And they gave then they had argued that that is the respondents, that is the submission of the person who filed the case. according to the respondents, 148 employees and the numbers on the signed check forms that were presented in court by the applicants were 45 and not 69. So their employer was disputing the numbers the union is talking about. It is not correct. They are saying they have already recruited 69, but the number we have in our employment database, they are only 45 because probably some had left and they were not there. Then, so there was the argument of the discrepancies justifying that they didn't have the 50+1. So that is why they could not sign a recognition agreement. And this case had gone for a conciliation. And what was passed, actually, it was found that the union didn't have the critical mass of 50+1. So it was premature for them to force the employer to sign a recognition agreement. However, for representation, they were supposed to actually deduct their dues. So the conciliator made a recommendation that the applicant had not attained a simple majority, hence it was premature for the applicant to seek recognition for purpose of collective bargaining, because we said collective bargaining is only backed by a signing of a recognition agreement, but membership, they could still collect the dues. So actually, there was also the other submission. So you'll see the submission of both parties, the to and from. And finally, we will see that in this case, the respondents was ordered to commence the immediate deduction and remittances of the union dues to the applicant with schedule of the names that had already been agreed on. Then the rest of the issues was to be resolved later, which was not part of this. So for me, that is it. It's a ruling. It is, but you can see the interaction between the union and how you can take each other to court and how we are relating to the provisions of the law that we had studied. So these cases, I think we'll also share with you. Then you'll find the notes in the learning management total of ACHRP. I always call them ICHRP, ACHRP for easy access. But if you take the course law, just Google, download, you'll have them on your desk. And that brings me to the end of my presentation, and maybe just go back to my final remarks, and then I take Q&A. The final slide on that presentation, so that I don't leave you hanging. So after the two, those are the two analyses of the cases that we had. And the closing remark for this, in matters concerning labor, industrial relations practice should be enhanced to create industrial harmony on matters labor. Because like those things for union deduction, if we agreed they are not 45, they are 69, well, what is so hard for you to deduct? If actually we have the list and we have the payroll and you have, these are the people in there, what is so hard to understand that we don't have the 50+1? But you can see the union is claiming the employer is trying to reduce the number so that they don't meet the critical masses. So they keep on terminating and dismissing them so that that number doesn't reach the 50+1. So they had a case. So Article 2, it is talking about the supremacy of the Constitution, as you have heard in the first case. And the general rules of international law shall form part of the Kenyan law. And any treaty or convention that is ratified by Kenya shall form part of the Kenya law of Kenya under this constitution. And that is it from me. So let's hear comments. I know time is not on our side, but let me just hear quick comments, reactions, whether now you have some level of confidence to go extract cases of employment and labor relations case and dissect them. Give yourself every week, I'll be downloading one case, or whether it's a small ruling or a big one, because it enlightens your understanding of labor laws in Kenya. Thank you. That's all from me. Let's hear from you. Patricia. Patricia is on the other side. Let me bring her on. And John, let me hear your comment as we bring Patricia back for the closing remarks. And we can't hear you. And kindly unmute. Or John. Patricia?
Rhoda,
Yes, and now I can hear
I'm
you.
in a noisy place.
That's
I told you
okay.
I was coming for chanjo.
Oh, okay.
For
So
the
that's
vaccine.
mm,
So I'm on the queue.
all right. So
Yeah,
John,
but
Patricia,
I appreciate. I've had everything. Yeah.
good.
Okay.
John, you're good?
Yeah.
Mhm. Patricia.
Yes. Thank you, Rhoda. Yeah, indeed, the case laws or the case studies, I think to me, they are real issues. And apparently, although we have the laws in place, sometimes they are broad enough, but there's there's always a unique case coming up that will really require a lot of interrogation. So it is really, again, a call to action that we familiarize ourselves with, previous or precedences that have been set. So, as we even do our work as professionals, then the teams we are leading can be guided by, the information we have from the very reliable, sources, the courts. Those ones are, we cannot dispute them because rulings, they are standards. They are already standards set. And it's just us now to align ourselves with, because we will run to the courts in one way or another. So it is good, as you say, we need to have at least, make it a practice to liaise and know what is going on, how our cases, and situations where conflict in the workplace where you're dealing with human beings, these are the things that will always come through. So to me, it's again an eye opener, and it's almost clear that you cannot sit in what you are trained to do. You have to go the extra mile. As you go higher the rank, then the responsibility and expectations are even bigger and broader than what we really thought we should handle. So I'm very grateful, and this has not been easy. This is where now you start feeling you are a professional of experience, and many years in office can teach you a lot. So I'm happy that I actually signed in, and it's been a year where I can feel, yes, I didn't know so much. I thought I knew, but when it now comes to dispute and handling dispute and even relating to the union, it's now not what we ordinarily know. There are standards, there are terms and conditions, and how we can really partner. And again, whatever we do, administration of fair justice in life, I usually say, tenda wema nenda zako, so that your conscience is clear that when you are there, your record can speak for you. So I'm very, very grateful, and I thank John. John has observed that at least the HR, today's HR, we are not, our staff should not be victims, and we are villains. So, it's not a competition. It is just coming up with a work environment that can make, parties do their best when they're there. Because they're so valuable, anybody else can hire them. So if you give them the right work environment, they'll support your cause. And to me, sometimes the management may look at HR as the opposition or the activist and the voice of all that manner of thing. But where justice is not served, I think it is imperative that we change the course of the employer, treating or looking at the employee as, an asset, but not, a valuable partner. So the conversation has to change, and so that we treat our, we work in harmony. Yeah, to me, sometimes they call me the dean of staff affairs. I've also been accused in some of those meetings that I have dangerous love for the staff, and I told them all love is dangerous because we speak facts. Because we feel them. We have the pulse of the staff, and we should not be afraid to bring them out. And I'm just happy that the law recognizes that all what is being said is just fairness, and where corrective measures have to be done, they have to be done again in a very fair manner. So thank you so much, Rhoda. I thank the team, John and Anne, the other side. I think this was time very well spent. This is a week where I think my diary should capture some very good achievements, milestones in the week. I must say, asante sana. Yeah, thank you.
Thank you, Patricia. So for me, I must say, I really appreciate you, John, Anne, and Patricia. We have been a small class, but very participative, very instrumental, very insightful. I'm proud of the kind of experience and knowledge that you're bringing from our experiences where we work. And I wish we could be having such forums regularly just to sharpen. They say iron sharpens iron. And for me, it has also been a learning experience. I've learned a lot from you, Patricia, from John and Anne. And it has also made me look at perspective differently in our practice, in our professionalism. And let's become learning people. There's no end to this learning. So with that, I want to thank you very much and for concentrating, giving your ear, your time. I have enjoyed this session. So with that, I know the certificates and the material, you'll be able to find them in the Learning Management Information Portal for ACHRP. And Dan will be able to facilitate you in terms of any contacts you may need. He'll be able to. Dan, are you there? Probably Dan. Are you with us? He had said he's actually very active in the other physical. So without much ado, I want to declare this session and this summit, the 6th Industrial Relations Summit, officially closed, and invite you to look at the other trainings that are coming on board for ACHRP so that you can roll. They achieve very courses, but very in-depth in terms of the discussion. So thank you very much, and I wish you a good afternoon.